It is not the regular thing. Yeah.
Yeah, part to mention my lord. Item 160 my lord. Kali public to use.
Yeah.
Item 160 my lord.
What is your memo?
Sex
What
for
is your
interim
good name?
bill.
Satish Kumar Janaman.
Huh?
Satish Kumar Janaman.
Interim bill.
Satish Kumar General and counsel for the petition. Files and memo. Withdrawal of the CORAM's petition. Memo is taken on report. CORAM is disclosed of such withdrawal. Interim order is finished and back to it.
Pardon, my lord, item number 35. 1 week after.
Wait. Registration.
My lord, item number 118. 118.
Yeah.
118.
Which one?
118.
That is DLHL number 11255-25.
My lord.
That is your memo. Your good name is
Vibhuti Bhushan Rao.
Mr. B.B. Rao, Land Council, appearing for the petition. Files in memo. For withdrawal of the bail application, memo is taken on report. So far,
Supplementary list, item 1.
Yes, please, my lords. My lords, offense under robbery pertaining to taking away 5,000 rupees of cash from a truck driver, my lords, 3 unknown individuals. They stopped the truck, pelted stones at it, and took away 5,000 rupees of cash.
Since when you are in custody?
My lords, custody since 18/9/2025.
What do you say, Mr.
As the rejection order show that other co-accused not to have yet been arrested. So,
Have the land petition and land council of the state, considering the submission made by the land council for the petition. So the petitioner is in judicial custody since 18/9/2025. And charge sheet submitted.
No, my lords, charge sheet not submitted.
And the investigation has made substantial progress. And it's a case of commission of robbery of rupees 5,000 from a truck driver.
Truck driver, my lord.
Right. And offense is liable by magistrate, and after hearing the land council for the state, who submitted that co-accused persons are yet to be arrested as per the order of the land and in court below, and inclined to release the petition and they allow it.
Item 2.
May I please, madam? Two young boys are in custody. The two petitioners are there. Charge sheet in the
20
meantime.
B, 21 kg का
City of the
PD in
city and the criminal anticipation.
Not that. No, para. Subject to proceed.
Item number 3.
Item 3.
No, please, madam. The case of robbery, madam. Petitioner is in custody, lordship 613/325. She Justice has been filed in the meantime.
When you are in custody?
13th of March 2025. 13th of March 2025.
Charge sheet submitted.
Justice
Under which of them?
robbery, my lord, 309.
9
Subsection 4 of
What is the subject matter of them?
subject matter, my lord, the 12-wheeler while filling the
It appears that you are involved in 32
cases.
cases, and those cases are arms act. You got the criminal the details of the status of those cases.
I'll get the details.
Are you having those details?
Yes, madam, that is the 32 cases in the
Those lists are with you.
the list with you.
You file a comprehensive application. The Land Council for the state submit. You have received the case diary.
Yes, madam, case diary.
Submit that we have received the case diary, and on verification submits that there are 32 numbers of criminal antecedents against the petitioner, including the offences under section 397, 392, 457, 380 of the Indian Penal Code, and section 25 of the Arms Act. In various police stations, Land Council for the petitioner seeks some time to obtain instruction relating to the status of all those cases and file a comprehensive affidavit in that respect. Of this matter. Yes, next one.
Item 4.
May I please, madam? The petitioner is a lady not named in the affair, and the 3,82,000 is the crux of the matter. The from co-active persons, cash and other mobile phone or other articles recovered. In the present petitioner, nothing has been recovered.
There are 3 petitions.
3 criminal answers.
Madam, due 3 criminal assets, he has been.
She has been mentioned. There are 2 male persons. One is lady.
One is lady. One in respect of the present petitioner.
You are pressing for only that lady.
Madam,
Are you pressing the bail application only for
only Basan divisions. Other अगर file करनी.
other you don't want to press?
नहीं ना other अगर file करनी. Only Basan divisions file.
Only petitioner is
Basan divisions.
এটা কোন মাস করছো?
ସେସନ ଜାଗାରେ 3 ଜଣ ରିଜଲ୍ଟ ହେଇଛି ମୁଁ ଏଠି କୋଉ ବାସନ ବିଶ୍ୱାସରେ
সেটা কি গেল আর? প্রিন্টেড বসে। Since when you are in custody?
13/9/25 में
The offense is now 308
हाँ this can converted to
bracket 5.
388.
Extortion by putting a person in fear of death and grievous assault. So, imprisonment for 10 years. So, what is the allegation against this lady?
against lady
She is in custody since 13/9.
13/9/25
What they have done?
the other co-accused persons took the informant over telephone in a hotel and then to another hotel and to him into jungle and demanded rupees 3 lakhs.
Has it been taken or not taken?
And 3 lakhs, as per rejection order, 3 lakhs they have taken.
Yes, Mr. Nair, what do you say?
12,000 also recovered from the
Recovered from the petition.
No,
mobile phone, knife, and
Co-accused.
co-accused.
No,
16.
anything recovered from the petitioner as per the
This
rejection order?
कुछ नहीं है ये.
This lady has 3 criminal cases.
In
Malkangiri police station.
3 criminal cases, she is acquitted in 2 cases. In 1 case, she is on bail.
Have you given a copy to the state council?
इधर acquittal है कि whatever bail is, whatever middle land
This
is one.
Jayanti Vishwas is who?
She is the sister of the petition person.
Not the land council, but the petitioner land council for the state. Land council for the petitioner has filed an affidavit of the sister of the petitioner, wherein it is indicated that out of 3 criminal antecedents, as has been pointed out in the rejection order, in 2 cases, the petitioner has been acquitted, and in the 3rd case, he has been directed to be released from bail. The comprehensive affidavit, along with the document file, taken on record. Considering the submission made by the land council as the petitioner, that the petitioner is a lady and she is in judicial prosecutions 13/9/2025. Charge sheet has been filed or not?
No, man, substantial proof.
And the investigation has made substantial progress. And offense is traveled by magistrate. After hearing the land council for the state, I'm inclined to release the petitioner.
Privilege.
Then
Item 5.
Item 5 to TV tools in my left.
commercial quantity.
still
Have you got the case there?
no, they did.
CD and criminal and testing. Yes.
Item 6.
Okshay.
Oxo is there, so notice to this. Let's see, none of the others.
Item 7.
You have got the case diary?
No, my lord, it is not.
And what are the CD, criminal antecedents, and the statement of the victim. 164 of the Noah, we can tell it.
Item 7. May I please your Madam, on behalf of Mrs. Amita Sahu, Madam, offense under section 310 clause 2 BNS Act, read with section 2527 Arms Act, Madam. 310 clause 25 million, 395.5 million.
Yes, okay. So have you brought the,
Yes, it is available. 27 Arms Act is 2529.
no, have you brought the case diary?
Yes, my lord, case diary.
What are the materials against
Allegation, my lord, the informant is a driver of pickup van, my lord, with
Yes.
loaded of fish and 37 numbers of Simtex boxes on the way 8 to 10 persons, being armed with deadly weapons like sword, gun, etc. detained his vehicle near the hump. One of the culprits broken down the front glass panel of his vehicle by means of a sword. The other accused person dragged him and assaulted him by means of a kick and
No,
pistol.
it's all right. FIR was lodged against.
Yes, ma'am.
So what has been, whether the TI period has been from that case? Since when you are in custody?
Custody, my lord, 13/9/2025.
TI period ହେଇଛି?
No, madam, yes, madam.
ହେଇଛି ମାନେ ନାଇଁ ଆପଣ
ନାଇଁ ଆମ ପାଇଁ ନାହିଁ ରିପୋର୍ଟଟା ଅଛି।
କରିବେ କି ନାହିଁ ପ୍ରଥମ କଥା ଯଦି କରିଛନ୍ତି ତାହେଲେ ଆଣନ୍ତୁ। ଦ୍ୱିତୀୟ କଥା ହଉଛି what about the criminal antecedent? Have you got the
No.
instruction?
As per my instruction, my lord, petition number 1 has one criminal antecedent and petition number 2 has no antecedent, my lord.
But take instruction about
No.
this. What is your instruction? TI period.
No instruction, my lord.
It's a case of dacoity and the FIR has been lodged against unknown person. So the Land and Council for the state has received the case diary, but he seeks for an adjournment for an instruction, not only relating to the criminal antecedents of the petitioner, but also whether any test identification parade has been conducted, and if so, to produce the TI parade report on the next day. Put up this matter, Mr. Sanchez. Yes, ma'am.
Okay.
Item 8.
20 feet, 21 kg ganja.
Is there available?
No, kg.
CD and criminal antecedents.
Item 9.
My will
Next, my lord,
My lord.
OPID case and economical
petitioner.
PWD and OPID, I think
You
OPID
given a
panel,
copy to the council.
OPID panel.
State surplus.
OPID panel ଅଲଗା council ଅଛନ୍ତି କପି ଦେଇଛନ୍ତି ତାଙ୍କୁ like ବିବେକାନନ୍ଦ ଭୂଇଁଆ ଏସି ପାତ୍ର ତାଙ୍କ panel
ହଁ, ସେ panel.
please serve a copy and
ଫୋନ କରିଥିଲି ସେ ନେଇନାହାନ୍ତି ଆଜି ଦେଇଦେବି
ହଁ
today I will serve.
ଲେଖନ୍ତୁ
Since short date I prefer the petitioner is in custody since 2016 man. Sorry.
petition is taken into custody in connection with an offense under OPIDR, and there is separate panel of counsel who are from the state of Orissa who are dealing with such cases. There is a copy of the bail application you served on the Land and Council. Shall obtain the case diary and other necessary instructions on the matter. Put up this matter on such and so forth. Copy the instruction.
Date fix kar.
Date
Only after.
evening we ଆପଣ ଦେଖିଦେବେ due date ହେଲା।
Item 10.
Charge has been filed on the SC/ST Act. So I am permitted to file appeal this 103 SC/ST Act.
What is your memo? Give a memo. Mr. Sanjeev Kumar Bhasdev and counsel for the petition files a memo for withdrawal of the case. The memo is taken on the court and the bail application is disposed of as withdraw.
File appeal.
Hmm?
If I SC/ST Act.
You just mention it that.
Item 11.
May I please? The petitioner is in custody since 26/2020 for the commission of offense in the section 498 302 34 of the Indian Penal Code, read section 4 of the.
What is the offenses under which charge sheet submitted?
My lord, charge sheet submitted.
What are the offenses?
498 302
498A 302
34 of the Indian Penal Code, read section 4 of the 4 of the DPR.
Who is this man?
Petitioner is the husband.
Husband.
Custody
What is the name of the deceased?
My lord,
Kona?
Ashwini.
Deceased or not?
Ashwin sir.
Ashwini.
Name of the sorry.
Trial has commenced.
Mal-
You are in custody since when?
since 20 मतलब 26/5/2020 out of 31 numbers of charge sheet witness and only 18 witness was examined during the course of trial.
41
31
41 ना 31
18
नहीं total witness
41 मतलब
41. So you have come to this court earlier, and as it seems that thrice your bail application was turned down. This Rabi Sahu ke
Rabi Sahu hଉଛି ୟା ବାପା
Father-in-law.
father Netrang
District-
Rabi Sahu is the father of the present
he
petition.
has been granted bail.
He was granted.
So far as the petitioner is concerned, has he approached this court earlier? ना अपन पर किसी इंस्ट्रक्शन नहीं.
No, he was
Nitrananda Sahu. ना पिंता को Rabi Sahu.
Rabi Sahu.
So that means you are in custody for
Near
more than
about
5 years.
5 years and
What is the cause of death?
burning alert.
kerosene ढाली पड़ी।
Burning. What are the materials?
Admittedly, there was no eyewitness.
Yes,
There was
witness is
other
there.
chance occurrence witness.
There are 161 statement is there that
No, eyewitnesses.
Yes,
No.
yes, ma'am.
Here they keep.
the Dedsura Taja.
They are not the accused here.
No.
No, it is not.
What they have stated. But Dersuro Nago
After
After Sahu.
After Sahu here.
हरिमणि साहू का जा
कौन कोई relevant पार्ट पर
ठीक से समय मो झील सुप्रिया साहू पारिपटू परीक्षा करने जाइला झील आसिक कहला जे माँ को काकी शब्द शुभुची से नाना बंचाओ बंचाओ बोली कहूचे आमे तापरे एवं मु मोर स्वामी बारिपट गलु बारिपट एवं आमर बारिपट घर मध्य पूरा लगी सेठी जाई देखुली जे निया फुलाटी जलु थाए अस्मिन साहूर देहरे तापरे आमको देखिली तार स्वामी एवं तार शशुर आमको देखि दौड़िकी से घटनास्थल पलाई गले तार शशुर आमको देखि पुणी फेरी आसला एवं मोर स्वामी जेतेबेले कहले एका किरे कलु तू हठात से हठात रवि साहू तार शशुर से पिंधिथिबा धोती खोली देई से निया झुला को लिभा पई चेष्टा कला तापरे मोर स्वामी सेठू गछपट आसिकरी निया को पूरा लिभेई
गोटे होची अक्षय साहू आ गोटे कियो देखिला
अक्षय साहू
स्त्री
हारामणि साहू एवं ता झियो भी मध्य
जस्ट हारामणि साहू
साहू
आउ
Hiraman.
हाँ हिरण
आउ झियो ना कोन
ये वाला सुप्रिया सुप्रिया साहू
सुप्रिया साहू एज केतो
18 वर्ष consist पर
अच्छा these you said that 18 witnesses have been examined. These 3 witnesses have been examined. You have given the copy of only 9 witnesses.
In the meantime, after filing, there are other witnesses have been examined.
No, we just want this particular 3 statements. They are the eyewitnesses or they were present. So you take instruction on that.
Madam.
The learned counsel for this petitioner submitted that this is the first bail application of the petitioner, who is in judicial custody since 26/5/22. And in the meantime, trial has commenced, and out of 41 charge sheet witnesses, 18 witnesses have been examined so far as per his instruction. However, he has filed the deposition copies of only 9 witnesses and seeks some time to obtain the certified copy of the deposition of the rest of the witnesses and file the same. Stop paragraph. And counsel for the state has received the case diary and pointed out that it's a case of a burn injury and S.K.Sahoo, the elder brother-in-law, Haramani Sahu, the sister-in-law, and Supriya Sahu, the niece of the deceased, respectively, are very material witnesses who have stated about the occurrence. The learned counsel for the petitioner shall obtain specific instruction regarding the examination of these three witnesses and shall produce their statements. If those three witnesses have not been examined, the learned trial court shall make every endeavor for summoning those three witnesses on the priority basis and examine them. Put up this matter on such and such date. Yes. A copy of the order be communicated to the learned trial court. File be placed before the learned registered judicial. Yes, next.
Item 12.
May I please your lordship? The petitioner has been implicated in an offence under section 296, 352, 115 to 118 of the 18(1) of the BNS Act and languishing in custody since 8/9/2025. Corresponding offence 294, 506, 323, 324 of the Indian Penal Code. In the meantime, charge sheet has been submitted. Prosecution allegation is that the petitioner went to the hotel of the informant and found that the hotel was closed and one of the
These are all magistrate tribal offences.
but in the meantime, the charge sheet has been submitted. Of the injured has sustained one grievous injury.
No, but charge sheet you said submitted under these offences.
No, my lord, in the meantime, charge sheet submitted. I have given the statement of the.
No, what are these offences under which charge sheet submitted? Have you got a copy of the charge sheet?
No, my lord, no, I have not received the copy of the charge sheet, but I have given the injury certificate.
Who is the injured?
One Joga Behra.
He has sustained one grievous injury.
Hathata fracture which I have given the certified copy.
And since when you were in custody?
My lord, I was in custody since 8/9/2025.
What is the weapon with which you assaulted?
ବାଡ଼ିରେ ବାଡ଼େଇ ଦେଲା ତାକୁ କହିଲା ଯା ମଦ ଆଣିବୁ ସେ ଯୋଉ ହୋଟେଲ ମନା କଲା.
Any criminal antecedent?
One criminal antecedent
Two criminal.
ଦେଖେଇଛନ୍ତି ଗୋଟେ
That is the
rejection order so that
Barcode PS case number
Barcode PS case number
474 of 2024.
Yes, another
25 of 2020.
এইটা please.
out of barcode 325 or 20.
এইটা
Out of 1474/24.
Dita criminal.
Dita, yeah.
Or the learned counsel for the petitioner and counsel for the state. Considering the submission made by the learned counsel for the petitioner, that the petitioner is in judicial custody since 8/9/2025. Charge sheet has been submitted and the injured Jaga Pradhan has sustained one grievous injury. And after going through the injury report, certified copy of the injury report, and the statement of the injured, which is filed, which are filed by the learned counsel for the appellant and taken on record. After hearing the learned counsel for the state submitted that there are criminal antecedents against the petitioner and inclined to release the petitioner from somewhat indulge in any criminal
Item 13.
May I please your lordship? Lordship, I am VC from Balangir. May I please your lordship?
Yes.
Lordship, I am for the petitioner. This is a case under section 302, 201, 120B and 34 of IPC. In this case, there are two accused persons. One is the juvenile and another is the present petitioner, who is a 65 years old man languishing in custody since 30th May 2024, 1.5 years. Lordship, as per the case of the prosecution police, there is no eyewitness to the case. There is no circumstantial evidence against the present petitioner. The present petitioner has been tagged in the case in the name of section 27, confession and recovery. Those witnesses have already been examined by the trial court. There are 32 witnesses, out of whom 20 already examined, but not yet a prima facie case is seen against the present petitioner, Your Lordship. Your Lordship, the place of occurrence and the allegation is that, Your Lordship, that the deceased was playing in his village. One Padmalochan Bhoi, who is that juvenile, took the deceased towards Bagmara project, a separate place from the village, and later on in evening, the dead body of the deceased was discovered and has been seen by the villagers, Lordship. Lordship, in this case, the informant is the father of the deceased, who says that I have not seen the occurrence. Your Lordship may kindly see PW12 is the father of the deceased. His cross-examination, Lordship, that is at page number 91, Lordship. May I submit, Lordship?
You are at your instance, what was recovered?
According to police report, Your Lordship, a strip towel was recovered, and police says this is the alleged part of the towel which was tied on the mouth of the deceased, Your Lordship. But Lordship,
You are in custody since when?
1.5 year, Lordship, since 30th May 2024, Lordship.
In the rejection order, it is mentioned 3/5/24. So, is it a case based on circumstantial evidence?
Circumstantial evidence, but the PW7 is the grandfather of that district. He has stated that I heard from the Lakshmi Sahoo. He has not been examined yet.
Lakshmi Sahoo,
That the rejection order so that on the Lakshmi Sahoo has not been examined.
No. What Lakshmi Sahoo has stated. What is her statement in the?
Yes, Lordship. Lakshmi Sahoo stated, Your Lordship, that she has seen the juvenile taking the deceased.
It is not available.
She has stated nothing against me, Your Lordship. She has not seen the occurrence, Lordship. She has only seen the another accused, Your Lordship. Since Your Lordship may kindly peruse, Your Lordship, PW 17 and 18 cross-examined, Lordship, who have been placed by the prosecution as the witnesses.
First application before this court or earlier rejected?
This is the first application, Lordship. Lordship may kindly see PW 17 and 18 cross-examination, Lordship. They are the vital witnesses.
What is your good name and counsel?
Pramod Kumar Bohidar, Lordship.
You are appearing from Balangir?
Yes, Lordship.
Are the land counsel for the petitioner, land counsel for the state, land counsel for the petitioner submits that the petitioner, who is aged about 65 years, is in judicial custody since 3/5/2024, and there are no direct evidence in the case, which is based on circumstantial evidence, and at the instance of the petitioner, one Sambalpuri check stripe of Dhamusha was recovered, and out of 32 charge sheet witnesses, 20 witnesses have already been examined in the trial court, and no clinching evidence has come on record against the petitioner so far. He has annexed the evidence copy of the witnesses to the bail application. Land counsel for the state, on the other hand, opposed the prayer for bail and submitted that some material witnesses are yet to be examined. Considering the submission made by the land counsel for the respective parties, the nature of evidence available on record, the progress of the trial, the period of detention, the petitioner, and the fact that the case based on circumstantial evidence, I am inclined to release the petitioner on bail allowed.
Item 14.
Let me log. Custody since 21st/9/2025. Charge sheet submitted. Absolutely no antecedent.
What are the offenses under which charge sheet submitted?
Yeah.
What are the offenses under which?
123 and 305 PO. Allegation ହେଲା ଆମେ ଘର କରିବାକୁ ଯାଇଥିଲୁ ଆମ ସାଇଡ୍ ଘରେ the petitioner ଆମକୁ ଆସିକି ଗୋଟେ ଥଣ୍ଡା ବୋତଲ ପିଇବାକୁ ଦେଲା ତାପରେ ଆମେ କନସିୟସ୍ ହେଇକି ଗଲାରୁ ଆମ ଘରୁ ଗୋଟେ ବେକରୁ ସୁନା ଚେନ୍ଟା ଆଉ କ୍ୟାସ୍ ହେଲାନି।
Since where you are in custody?
Custody since 21st/9/2025.
Yes, Mr. Nayak.
Rejection order said that the informant and the husband of the informant were admitted in the Kotak Medical for their treatment.
You are giving some forgeries, and it stated that they took away 30,000 and gold chain from the neck of the on the land counsel for the petitioner and counsel for the state. Considering the submission made by the land counsel for the petition, the petitioner is a lady and is in judicial custody since 21/9/2025, and in the meantime, after completion of investigation, charge sheet has been submitted under section 123 and 305 of BNS. And after hearing the land counsel for the state, I am inclined to release the petitioner to the 437 CRPC the 11 BNSS provision. Yes, next.
Item 15.
Your Lordship, I am charged under Section 288 of BNSS, Section 5 of Explosives Act, Section 5 of Odisha Fireworks and Loudspeaker Act, and Section 9B of Indian Explosive Act. Your Lordship, I am a manufacturer and seller of firecrackers since last 7 years, till the COVID period. I have all the licenses, renewals, and authority-based papers that has been attached and annexed to this petition. Your Lordship, this petitioner has a 100% handicapped brother and some familial responsibility to take over. For that reason,
You are keeping this huge quantity of explosives in your house. That is the allegation.
Your Lordship, these quantities or these seized quantities are pertaining to the firecrackers making only. It has confessed in the suo motu FIR. Police has also admitted that he was caught while making and manufacturing of firecrackers.
But it is mentioned there it should not exceed the quantity and what sort of thing you can purchase, that is also there. So perhaps you are deviated from that. That is the reason.
Your Lordship, I am innocent. Actually, I have no criminal antecedents. I have just kept that stock under an oral assurance that my license would be renewed. For that reason, he just kept that stock.
That license which you are having filed, that was that expired since 31/3/2011, as it appears from Annexure 3.
Your Lordship, it expired on 2017, Your Lordship. On page number 20.
That was page number 20. It reflects that last time
2017
on 31/3/2017 and it is a 1-year license. So 2017 upon license nathila and this seizure was made.
Yes, Your Lordship.
In when? The 25.
सर ଗୋଟେ discontinuation period ଥିଲା ତାଙ୍କର handicapped brother ଥିଲେ ତାଙ୍କର medical attention ଦରକାର ଥିଲା along with that familial responsibility the financial constraint ଯେତେବେଳେ ଆସିଗଲା 2017 ରେ ତାପରେ ସେମାନେ ପୁଣି recontinue କରିଥିଲେ ଆଉ ଥରେ ମାନେ continue କରିଥିଲେ ଏଇଟା ବନେଇବା fire crackers ପୂଜା celebrations କୁ ଆଗେ ରଖିଲେ
The 50 kg gunpowder, 1 bag, and 25 kg potassium
No,
nitrate.
that he was having a license. The problem is that that license that it did not be that renewal was not.
yes your lordship
It was issued in 2010, and you will find that it continued, and in page number 20, it reflects
17.
that every year there was renewal. But from the last renewal seems to be on 31/3/2017. The signature of the licensing authority is also there.
yes
So
your lordship
thereafter, for 7-8 years, he has not renewed it, and but he was carrying on the business. That is the main issue. Any explosion took place or not? He's just keeping it at such.
no your lordship no lordship
Had the land council for the petitioner and land council for the state, considering the submission made by the land council for the petitioner, that the petitioner is in judicial custody since when you are taken into custody.
so since 23 September 2025 your lordship
9/2025, and the petitioner was having license to purchase and sell some arms and also for manufacturing fireworks. And that license was granted in the year 2010, and yearly renewal was made, but for some difficulty, the petitioner could not renew the license further after the last renewal was made on 31/3/2017. The Land Council submits that in view of the nature of allegation and since investigation has made substantial progress, their application may be favorably considered as the petitioner has got no criminal antecedent. Land Council for the state opposed the prayer for bail. Considering the submission made by the Land Council for the respective parties, nature of accusation against the petitioner, progress of investigation, and period of detention in judicial custody, and inclined to release the petitioner on bail.
highly obliged your lordship
Item 16.
Well, under in item 16, the FIR is lodged under section 318 clause 2 and 363, that is cheating and criminal breach of trust. The maximum punishment mentioned is 7 years. The charge sheet has been filed, and the allegation herein is the accused number 1, who was appointed as a person to take care of the accounts of the self-help group.
What you have done?
The accused number 1, who was appointed in the year 2021 to take care of the accounts of the self-help group. Since 2021 till date, she has misappropriated a fund of 29 lakhs. The petition number 1 and certain other local young boys used to take checks and deposit in their account and withdraw money for the self-help group. They do not have any access to the check or stamp or signature, but accused number 1 was in possession of those checks, stamps, and she used to sign. So there is no chance for the petition number 1 to know which check is real and which is duplicate.
There is only one petitioner. Why are you telling petitioner number 1?
Yes, my lord, sir.
There is only one petition.
Only petition.
Amir alias Udit Bag.
My lord.
So who was he in that And yet his goal was only to take those checks and put it in his account and withdraw money and give it to the that president and secretary. Who of which post he was holding?
My lord, I am clarifying, my lord. One Bonita Naik is the MBK of the self-help group, one employee. The checkbook, the seal of president secretary with Bonita Naik. Bonita Naik eloped with the present petitioner. Develop love relationship with the present petitioner.
Okay.
The present petitioner persuaded Bonita Naik to hand over the check using 26 number of check. All this signature, the sign of the president secretary are forged by the present petitioner. And to his account, 25 lakhs 13,000 transfer, check route transfer to his present petitioner's account, my lord. And that was not recovered. Bonita Naik is a victim in this case, my lord.
Bonita Naik is also in court.
Accused, he was arrested. Then सब पैसा ये नहीं है.
No, but what happened to that amount which came to your account?
Not directly, they used to issue checks because
No, the investigation reveals that from this Axis Bank account, you are having an Axis Bank account, and to that this money has come from which was deposited in your account by way of different checks. So that is what he stated, and it is amounts to 25 lakhs.
that amount is
You have withdrawn that amount.
I have to withdraw cash and give it to the self-help group. Similarly, other accused, if my
You have
lord
not given
Bharat
it.
page 12,
Now self-help group has sustained loss because it has gone to you, your account, and you have withdrawn it, and you are giving that explanation that I have spent for this, that. So that is a matter which is to be decided at the trial.
Bonita Naik also confessed that out of that 25 lakhs, the present petitioner has given her some amount.
So what is the stage of investigation?
my charge has been framed.
Investigation.
So charge sheet submitted, charge has been framed.
My lord.
What are the offences? These are all magistrate tribal offences.
Yes, my lord.
But the question of recovery of this money, my lord, the society will collapse completely if the money will not be
Well, that
secured.
is to be ultimately it is to be proved in the court of law, and if it is found guilty, appropriate order can be passed.
Account transaction. So
But
check and
account
all these
transaction.
checks have been seized. Sabu check re the present petitioner backside check backside
Petitioner Land Council for the state, considering the submission made by the Land Council for the petitioner that the petitioner is in judicial proceedings 14/8/2025. After submission of charge sheet, charge has been framed and all the offences are triable by magistrate. After hearing the Land Council for the state was submitted that it's a case of cheating and misappropriation of rupees 25 lakhs of the
13,000.
30,000 of the self-help group. I'm inclined to release the petitioner on bail subject to condition that he shall appear before the London trial court on each date with the case shall be posted and shall not try to tamper with the evidence. Violation of any terms and conditions and until cancellation allowed.
Item 17.
I have filed a copy of the schedule list. Two applications are there. So far, BLAPL number 11052 is concerned. Nothing has been seized from the possession, and the basis of implication is the co-accused statement. As per the prosecution case, it is alleged that in a car, the co-accused, who is the petitioner of BLAPL 11275.
20B to a check.
No,
Commercial
have you received the case diary?
No, man.
Yes. CD and criminal antecedent.
Item 18.
May I please, Your Lordship?
145 liquor, ID liquor.
In custody since 26/9/25.
Okay, Land Council for the petition on behalf of the state considering the submission made by the Land Council Secretary that the petition in the judicial prescriptions 26/9/2025. The investigation of the central privilege is offense which is tried by magistrate. And after hearing the Land Council for the state, I'm inclined to release the petition on case allowed.
Item 19.
My lord, the petitioners apprehending their arrest in Barons of East
Apprehending arrest.
My lord, thereafter, by virtue of an order passed by this honorable court to surrender before the learned court below in the first hour, and subsequently to move well, if in the event rejection, they surrender before the learned.
It's all right. So now you are
My lord.
judicial custody.
And surrender before
What
the
are the
learned court
offences
below
here?
on 14/10/2025.
No, it's all right. What are the offences?
My lord, offense 115(2), 127(2), 296, 308,
10 years.
38.
Extortion 10 years.
My lord, background of this case is like this, my lord. Petitioner number 2 is the sales executive of the construction company, my lord, Shubham Construction. My lord, as far as the informant is concerned, he is the supervisor of the construction company, my lord. There is some dispute between her regarding payment, and in the meantime, the matter has been amicably settled. The informant is also entering into appearance before my lord. And all the offences are tribunal magistrate first class. And voluntarily I surrendered before the learned court below.
There is a order from the anticipatory bail application.
My lord.
On that basis, you
My lord, my lord.
So who is the informant?
My lord, I have to obtain instruction, my lord.
Where is your affidavit?
I've already filed.
Whether the genuineness of this affidavit.
This somebody called Jyoti. Jyoti.
Jyoti Mathan is the informant. Who is the supervisor of
the copy of that affidavit?
My lord,
Commission put it.
receive but I have to obtain instruction regarding genuineness of this affidavit.
oath commission ହିଁ କରିଥିଲେ।
କରିଥିଲା ଯେ ସିଗ୍ନେଚର ଏଠି ଯୋଉ ଭୋକଲାତନାମାରେ ଅଛି ଆଟଲିଷ୍ଟ ସେଇଟାକୁ ମଧ୍ୟ ଟାଲି କରିବା ପାଇଁ ମଧ୍ୟ ନାହିଁ ମୋ ପାଖରେ କିଛି ଦେଖିବା ପାଇଁ।
No, you take instruction. There is nothing about since this is coming for the first time, you take instruction.
Case date also not clear.
Mr. Naik, Land Council appearing for the state, submitted that he has not received the case diary. And one affidavit seems to have been filed in the case by the informant, Jyoti and
Mathan,
wherein it is indicated that the matter has been amicably settled between him and the petitioners. He has to obtain instruction regarding the authenticity of the affidavit. In view of such submission, put up this matter on such and such day, the Land Council for the state shall produce the case diary and also obtain necessary instruction in the matter. Yeah. Yeah.
Item 20.
Please, your lordship. Offense under section 82(35)(103) of VNS.
State is not there.
Custody since
304.
Taking suicide, commit suicide, lordship.
Also, case diary, lord's first time. Case diary, criminal matters.
Item 21.
My lord.
11 kg ganja.
What is
And
the date
custody
of
since
custody, madam?
28 September 2025.
28 September
My lord.
2025. Are the Land Council for the petition of Land Council in the state. Considering the submission made by the Land Council for the petition The particular judicial proposition should include 9 the quantity of ganja stated to have been seized from the possession of the petitioner is 11 kg, which is lesser than commercial quantities, and therefore, section 37 of the NDPS is not applicable. During the land council for the state, I'm inclined to release the petitioner and allow that.
Item 22.
May I please, your lordship? May I please, your lordship?
Yes,
Already in the meantime, case turned to 6 POCSO. Notice is got.
yes, sir.
Mm, mm.
And have you received the case diary?
Yes, my lord.
To submit that though case diary has been received, but it appears that the case has gone to one under section 6 of the POCSO.
My lord, it is my humble prayer to the your lordship that the case now stands for trial.
Yeah.
Two adjournment has been passed in the trial court, and the trial court has summoned to the victim and also the parents of the victim. But they are avoiding to
They are not
they are
appealing.
avoiding to come to the court and deposit their statements, deposition.
Since
Okay,
when
so my lord, it is my humble prayer. Let him and date a 10 days date for which we come to the deposition of the victim and the
since
parents.
you are in custody,
13/6/2025.
13/6/2025.
why so hurry? The incident took you have just taken into custody 5 months back. Court has issued a process and they are supposed to let the land council for the petitioner submits that even though twice summons have been issued to the victim as well as her parents to adduce evidence, but they have not turned up give evidence.
My lord, and in the meantime, victim is coming to the court to deposit their her deposition, but parents are not coming to the court.
No,
That's why.
victim has been examined.
No, my lord, victim has not been examined. Still,
Alright.
he comes to the court in each posting date in the trial court.
For the trial court shall do the needful in expediting the examination of the victim and her parents. A copy of the order be communicated by the land and registered officer to the land trial. Yes, next.
My lord, notice.
Notice that problem.
Item 23.
Mr. Pradeep Kumar Pradhan and S. Mahapatra. What is the offense here?
307. The FIR reveals that the petitioner one eye was removed due to assault.
Nobody is appearing. You have received the case.
No,
Look, non appears the land council for the state. 6 some time to produce the case diary. Put up this matter urgent. Case diary as well as the criminal anticipation.
Item 24.
May I please, your lordship? Your lordship, the major section involved in this case is 1091 of the BNS, and the corresponding section is 307 of IPC. The allegation is that on 9/9/2025 at about 7:30 p.m. to 8:30 p.m., the present petitioner along with 6 to 7 persons came with 3 bikes and assaulted him and give grievous injury and threatened to kill in life and abuse in obscene language. The petitioner is in custody since 11/9/2025 and the injured has already been discharged from the hospital since 11/9/2025.
What is the name of the NGO?
Sahoo. He sustained 5 number of previous injury.
The head injury also.
Yes.
There CT scan was done,
Sir.
but it is mentioned that he has been discharged from Balangir but referred to Bhimsar Burla for better treatment.
Sir.
So what happened? Whether he's okay now?
Health concern I have
He is
to.
okay. And he has, to my information, Your Honor, he has never been to Bulla for his treatment.
Okay, the State Council let him obtain instruction about the health condition. The Land Council for the state submitted that though he has received the case diary by Janto.
Yes, sir. Case diary received,
But from the rejection order, it appears that though the injured S.K.Sahoo was first admitted in BBMCH Balangir for treatment on 9/9/25, but on 11/9/2025 he was discharged and referred to Bhimsar Burla for better treatment. And he is yet to obtain inspection relating to the present health condition of the injured. The Land Council for the petitioner, however, submitted that he has got inspection that the injured was never treated in Bhimsar Burla.
And now he is moving in
Now
Poland.
his health conditions is good. Let the matter be stayed on circumstances that the Land Council for the state will obtain the health condition, instruction regarding the health condition of the NGO. Yes, next. It will also be criminal activity.
Item 25.
Ticket number 20B2B.
16 kg ganja. 16 kg ganja.
Rejection order.
PR I am also. I'm giving the PR to sir.
February
16/8/43.
16/8. The Land Council for the petition and council of the state, considering the submission made by the Land Council for the petitioner. If the petitioner is in judicial custody since 16/8/2025, and in the meantime, final PR has been submitted. Copy of which is
Final.
Yeah.
Final.
PR. Yeah, and he has submitted the prosecution report which is taken on record. And further considering that the quantity of ganja stated to have been seized is 16 kg, which is less than commercial notation, and which bar under section 37 of the NDPS citation applicable. And after hearing the Land Council for the state, I am inclined to release the petition.
One more prayer. In the post title, the petitioner number 1 is belongs to the district Subarnapur. That has been letter B is missing. Finally, consultatory post.
Who petition?
Petition number 1 or district number.
District na Subarnapur is.
SUA.
SUB हवा कथा SUB
Subarna. Acha B টা omit করছি.
Omit consultatory post.
The Land Council for the petitioner submits that the petitioner number 1, Padmanabha Kshatriya, belongs to Subarnapur district, but in the post title it has been inadvertently mentioned as Subarnapur, and he is filing a first post title which may be accepted. Land Council for the state has no objection. The fixed post title, which is filed today, is taken on record and shall form the part of the record. Yes.
Item 26.
T-Dweller 109 307 injuries are simple in nature that are being reflected in rejection order, paragraph not last paragraph, running page 14, and the name of the present petitioner does not find place in the affair. And more so, my lord, the main prime acute Sahoo in the meanwhile released on bail by the London Trial Court, but the London Trial Court did not consider my application in view of my criminal antecedent. I have one case.
of 302.
Only injury simple, monare.
ठीक है, but they have violated that bail condition.
Mona FRNI.
You are in custody since when?
Custody मिला
25/8.
28/8/2024.
No, 25 Act. The petitioner was arrested at the spot. While the
25
while the petitioner and others, they have no enmity with the injured my lord. Law of affairs. एमाने जाइन ता घरे पसिकी ताको बड़ाबड़ी करतले. Some villagers have apprehended the petitioner and other. Handed over to police.
302 case.
Yes.
It is of which year?
302 my lord.
That a confessional statement of
that is of the year 2024. What is the bail condition? Petitioner has to file a complaint.
And how this case is related to that?
No. ये दादा
Kiran Sahoo the main in prime acute, he also religion bail by the
Kiran Sahoo.
Kiran.
He assaulted the injured.
No, specifically simply that's the 161 statement of the injured I'm placing.
परिवार उद्देश्य रे जाने किरण साहू एक लुहा पंजा पिंडी मोर मुंडो को अन्य जगह को मारी दिया
एमाने खाली
अन्य 5-6 जन विधा गोइठा इत्यादि मो को मारले
CSC treatment is that the injuries appear to be in simple English.
Yes.
That is, he is mainly telling about your
criminal antecedent and bail condition. If the petitioner is
and you are in custody for
near about 4 months. In methodology investigation ne au kare clear karibo thana re au 22 ବର୍ଷର ପିଲା ଆଉ କିଛି ଗଣ୍ଡଗୋଳ କରି 22 years.
And the land council for the petitioner, one council for the state. The land council for the petition submits that the petitioner was taken into judicial custody in connection with this case 25/8/2024. And in the meantime, charge sheet has already been submitted. And the main offense is under section 109 of BNS. And the first information report indicates that it was co-accused Kiran Sahoo who assaulted the injured.
Son of the informer.
Subha Arpit Mahapatra. Subha Arpit
Mahapatra on the head. And the said Kiran Sahoo has been released on bail. However, the bail application of the petitioner has been rejected in the ground that the petitioner has got one criminal identity. The land council for the state also opposed the bail application on the ground that the petitioner has misutilized the liberty and while on bail in the first case he has committed this present offense, and though the two offenses are not connected with each other, considering the submission made by the land council for the respective parties, the nature of accusation against the petitioner, the release of the co-accused on bail, and the period of detention of the petitioner for more than 1 year and 3 months. I'm inclined to release the petitioner about 1 year and 3 months. I'm inclined to release the petitioner on bail subject to condition that he shall not indulge in any criminal activity. He shall appear before the IACs of Purushottam police station once in a week on every Sunday between 10 to 12, and shall appear before the London Trial Court on each day to which the court case would be posted. They shall not try to tamper with the evidence. Violation of any terms and conditions shall entail cancellation of the yeah.
Item 27.
May I please? This is offense under 103 BNS matter. Petitioner and custodian matter.
That's in.
Okay,
Petitioner and custodian matter 13/1/2025. In the meantime, charge sheet already.
Just. What is the date of custody?
Date of custody matter 13/1/2025.
13/1
आगे
2025 चार्जशीट सबमिटेड.
चार्जशीट सबमिटेड 12/3/2025.
What are the offences under which charges submitted?
103.
103. What is the name of the deceased?
Name of the deceased matter.
Toru Bhukta. Toru
T-A-R-U.
T-A-R-U.
Bhukta.
Bhakta.
Toru Bhakta.
Bhakta.
B-H-A-K-T-A.
My lord.
What is the date of occurrence?
Date of occurrence, my lord.
12/1/2025.
12/1.
Yes.
You were arrested on the very next day. So, any eyewitness?
Yes, my lord.
Who is the eyewitness?
The daughter of the petitioner.
Daughter of the petitioner.
My lord.
What is her name?
Mandodari Bhakta. Bhakta.
They are related to each other.
Yes, this is the wife of the petitioner, and eyewitness is the daughter of the petitioner.
This is the wife of the opponent, petitioner. What that daughter has stated?
I am placing my lord.
Relevant class.
My lord. The daughter is 11 years. କାଲି ରାତିରେ ମୋ ବାପା ଆସିକି ଚୁଲି ଫୁଙ୍କ ନାଳିରେ ମୋ ମାକୁ ମାରିଲା। ମା ମରିଗଲା। ତାପରେ ମୋ ବାପା କହିଲା ଝାଡୁ ମାରିଦେ। ମୁଁ ଝାଡୁ ମାରିଦେଇଛି। ସେ ନଳିଟି ସେଇଠି ପଡିଛି।
So what about the witness might not have been examined?
Already out of the 12 witness.
No, that girl has been
already examined.
That.
All the witnesses are already hostile.
Is that girl is the only eyewitness?
Yes.
ଆଉ ଜଣେ ଅଛି son ଅଛି ସେ ବି hostile ଅଛି.
The Mandodari Bhukta.
ଆଜ୍ଞା.
Informant is my so-and-so, deceased is my mother, accused is my father. My mother died 2 days prior to last Mokoro. Acha. I had gone to school and after return I came to know my mother had been to the hospital. Later I came to know that my mother died. So she has been declared hostile. And what about that son who you
Exactly
ସେଇ କଥା କହୁଛନ୍ତି ମୁଁ ଶୁଣିଲି.
son ଲିପୁନ ଭକ୍ତା.
ଲିପୁନ ଭକ୍ତା.
examine ହେଇଛି?
ଆଜ୍ଞା.
କେତେ number ଯାକି?
ଲିପୁନ ଭକ୍ତା.
କେତେ number ଯାକି ନା ଲିପୁନ?
60.
examine ହେଇନି?
ହଁ ହେଇସାରିଛି.
ଆରେ ଆପଣଙ୍କ ପାଖରେ କପି ନାହିଁ?
ଡାଇରେକ୍ଟ ସାର୍ଟିଫିକେଟ କପିଟା ସଫା କରିଛି. ଫାର୍ଷ୍ଟ ଟାଇମ୍.
କଣ ତା ନାଁ?
ଲିପୁନ ଭକ୍ତା.
This has been examined as PW. Deceased is my mother, accused is my father. My mother died 2 days before. I had gone to village. After return, I found my mother is lying dead.
But the cause of death is due to hemorrhagic shock following the injury to liver.
That is a funko nalito iron pipe type. The learning counsel for the petitioner submits that the petitioner is in judicial custody since 13/5/2025, and he has been charged under section 103 of the BNS, sir. ठीक तो? 103. He further submits that though the prosecution has projected that the son and daughter of the petitioner and the deceased, Gaurav Bhakta, to be the eyewitnesses to the occurrence. But in the meantime, trial has commenced and they have been examined as PW4 and PW5 respectively. Son and daughter. And both of them have not supported the prosecution case and declared hostile. He has filed the certified copy of deposition of the witnesses, which has taken on record. Land Council submits that in view of the nature of evidence adduced so far, since at this stage there is no chance of tampering with the evidence, the bail application may be favorably transferred. Land Council for the state opposed the prayer for bail and submitted report that the doctor has opined death due to shock and
My lord, cause of death is due to
the deceased has sustained head injury.
liver. Hemorrhagic shock following injury to liver.
Asha, death has deceased has sustained an injury on the liver, and the cause of death was hemorrhagic shock to the for liver injury.
My lord, which is homicidal in nature.
Which has been opined to be homicidal in nature. Considering the submission made by the Land Council for the respective parties, since the eyewitness to the occurrence have been examined in the trial court and they have not supported the prosecution case. Taking into account the period of detention of the petitioner in judicial custody, I am inclined to release the petitioner on bail allowed.
Item 28.
May I please question? Custody since 3rd August 2025. Offense under section
Custody since
3rd August 2025.
3/8
Again.
2025
Again.
year.
Offense under section 276, 277, 296, 221, 351, surplus 3 of BNS Act. My lord, allegation is that the present petitioner is selling the S.K. cough syrup bottle in open place.
Adulterated.
My
lord, the petitioner has 4 criminal antecedents. Out of 4, 3 of similar nature.
Yes,
one is
3. Balangir Town PS case number 384 of 2024 under section 21B 29 NDPS Act.
Yes.
Balangir Sadar PS case number 389 of 2024 it's a different nature.
Sir,
Balangir Town PS case number 360 by 25 under section 276, 277, 296, 351, 3 BNS. Balangir Sadar PS case number 291 of 2025 under section 21B 29 of NDPS.
Sir, say chapter to bail ଅଛି 3ଟା ଦିନ ଆଉ ଗୋଟେ bail ଟା pending ଅଛି ଆମ High Court ରେ ସେ reach କରିନାହିଁ.
ଥରେ bail ଯାଇକି ନେଇ test
Similar nature.
Sir, one similar.
What is your good name?
NDPS.
Vikas Swami.
Land Council for the petition of Land Council for the state, considering the submission made by the Land Council for the
My charge sheet already filed, man.
The petitioner is in judicial custody since 3/8/2020. After completion of investigation, charge sheet has been submitted and the petitioner is a young boy, aged over 21 years, and after hearing the Land Council for the state, submitted that the petitioner is having 3 criminal antecedents of similar nature.
4 criminal antecedents. 4 criminal antecedents.
4 criminal antecedents. I'm inclined to release the petitioner on bail, subject to condition that the petitioner shall appear before IAC.
Madam, Balangir Town.
along with town police station once in a week. Other police station, other police station, once in a week for a period of 6 months on every Sunday in between them. Also, and shall not indulge in any criminal activity, violation of any terms and conditions. Shall enter the cancellation of it's allowed.
Item 29.
Not legalized. So this is the cough syrup case LLC. Second case.
In this case, 111 2B,
Yes.
organized crime.
LLC.
And the petitioner has 4 criminal incidents.
Obtain the criminal case diary.
Yes, the charges submitted LLC.
Case diary.
What about the
second case LLC? 2 persons came in a motorcycle and they have stated that the first accused person and other accused persons have given him money for this case LLC. And on similar footing, other co-accused persons
you are a student of
yes,
law street final year arts.
Second case LLC.
Nitish Sahoo.
First item, my lord, Hare Krishna Pradhan.
Objection order লেখা is to Nitish Sahoo is a student of
with items.
That 2 persons came in a motorcycle. They confessed that the first person
so you are selling adulterated cough syrup.
On the confession of a co-accused, I was arrested. Not in the spot.
Who is that co-accused?
Nitesh and Aditya. In the second item, with item. On the spot, there 2 boys arrested. They confessed that I and along with others.
So your involvement is on the basis of
confession. And on the same footing, other co-accused persons religion anticipating.
And the petitioner has 4 criminal incidents.
Not in similar.
You are in custody since when?
10/9/2025.
10/9/2025.
Yes, sir.
Are the land council for the petition land council for the state, considering the submission made by the land council for the petition, that the petitioner is in judicial custody since 10/9/2025. And his involvement in the case is based on confessional statement of accused. And similarly situated co-accused, namely Premananda Behera, has been anticipated by this court. ABLA case number 12031 of 2025 had an order dated 27/10/2025. And after hearing the London Council for the state, who submitted that the petitioner has got
4 criminal antecedent and offense under section 111 2B.
And inclined to release the petitioner on bail subject to condition that he shall appear before the IIC of Charavanda police station once in a week on every Sunday between 10 to 4 for a period of 6 months. And he shall not indulge in any criminal activities, violation of any terms and conditions, and entail translation of the law. Yes, next.
With item, my lord, from the possession of the petitioner, the adulterated cough syrup was seized.
Having no criminal actions.
And you were apprehended at the spot.
Yes, sir.
Yes.
And since when you are in custody?
10/9.
Are the land council for the petition land council for the state, considering the submission made by the land council for the petition, where the petitioners are young boys, aged about 21 years and 19 years. And who is that student?
Nitish LLC.
And the petitioner number 1 is a student who is prosecuting his studies in first 3 final year arts. JSIT, Padampu. And investigation has made substantial progress
Let's see, completed for this.
Completed.
Completed.
And investigation has been completed, charge sheet submitted. And after hearing the land and council for the state, emanakara criminal activity.
No action.
We submitted that the petitioners have got no criminal activity. I'm inclined to release the
Not
petitioner
କିଛି
on-
case diary ଗୋଟେ page ର ଗୋଟେ instruction ଅଛି ତାতে କେବଳ ନୀତିଶର କିଛି ନାହିଁ ବୋଲି ଲେଖୁଛି।
There are no criminal antecedent against the petitioner number one. The application is allowed, same condition. Here କରିବେ. Yes, next.
Item 30.
May I please? Petitioner custody matter 21/8/2025 offense under section 64 of BNS Act and 69 of the BNS Act.
କେବେଠୁ ରହିଛନ୍ତି?
21/8/2025 में
Charge sheet ହେଲାଣି?
चार्जशीट 11/10/2025. Victim is 45 years, petitioner is 21 years.
You are related to each other. PC ଶ୍ୱଶୁର କୋଉ ଲେଖା ହେଇଛି?
Dear, related
Hmm.
distance.
But she is a married lady, that
Married.
victim.
Victim married 45 years, petitioner is
Give assurance about marriage and continuing this relationship, she became pregnant. And heard the land council for the petition of land council for the state. Considering the submission made by the land council for the petition, that the petitioner is in judicial custody since 21/8/2025. And in the meantime, on completion of investigation, charge sheet has been submitted under section 64 (3) small m 69 of BNS. And after going through the statement of the victim, who is a married lady and also related to the petition, her sister-in-law, and stated about the physical relationship with the petitioner on a number of occasions, I am inclined to release the petitioner if they allow. I'm just coming within 2 minutes.
Item 31.
May I please, Your Lordship? Lordship, the petitioner alleges for the offence under section 338, 339, 340, 336(2) BNS, read with section 12 of Passport Act and 14 and 14 of Foreigners Act. And in connection with the airport PSK no 122, corresponding to city case 1043, pending by unit JMFC 5 Bhubaneswar. And the petitioner in jail custody since 21/6/2025.
What is the allegation against you?
The allegation that the petitioner hold two for both foreign that issued by Afghanistan and Indian passport, allegedly violating the nationality law.
My lord, the petitioner is a national of Afghanistan. His address is, his name is Muhammad Yusuf, son of Moti Khan, village PS, Logel, Kabul, Afghanistan, having passport, Kabul, Afghanistan passport number so and so. The petitioner, giving false identity, was staying at Katak Petition, my lord, and obtained a passport. He was apprehended. My lord, here the process is, after apprehension, all the information has to supply to the Afghanistan Assembly, Embassy. Thereafter, the Ministry of Home Affairs has to issue process of deportation. This is the process, my lord. Thereafter, he will be sent back to Afghanistan. Here, if the petitioner will be released on bail, this process cannot be completed. And it is a national threat, my lord. କଟକରେ ଆସିକି ପେଟିନସେରୀରେ ରହୁଛନ୍ତି ଆଫଗାନିସ୍ତାନର ଲୋକ.
I may permit it, Lordship. Lordship, they are the Kabuli wala. They are doing money laundering business. They are since before at the time of independence they are staying. With the forefathers are also staying. And I have given a supported documents regarding the this identity and
the learned Udmilo has mentioned.
Yes, Lordship.
That you are a habitual offender.
No, Lordship. We are having no criminal antecedent. We are having no criminal antecedent.
My lord, I have received the case date but not received the criminal accident.
He is a habitual offender as the record goes to show.
No, Lordship. There is no criminal antecedent till date.
The Planning Council for the state submits that he has received the inquiry. But since in the rejection order it is mentioned that the petitioner is a habitual offender, as per the record, he has to obtain specific instruction in that respect. And will have to be taken up on some other day.
Lordship,
what you are
yes, sir. I am placing some documents.
The current counsel for the petitioner has
and the preliminary copy of the preliminary charge sheet.
Some documents which are taken on record. This matter on such and so. Yes, next.
32.
My lord, 303 corresponding to 379 and other earlier offences, charge sheet has been submitted. And I filed the comprehensive affidavit already filed, my lord. The allegation that two persons named accused, they came in a fast food, there was a disturbance, and allegations made that taken away 15,000 rupees. But so far the petition number 2 is concerned, only 520 rupees was seized from him, and from the petition number 1, nothing was seized. And charge sheet in the meantime submitted, adding 112 B, my lord. 111
102 is organized crime, my lord.
Again, 341, 323 out of tribunal I've given.
You given the
already my lord. Since
so
long I have.
What is the status of those cases?
On the jail, my lord. Mentioning
the criminal incident of a comprehensive affidavit. I have to verify.
341, 323, so plus
6 cases is Lakshman Tudu and 7 cases against Lingaraj Behra.
341, most of the cases, my lord, 341, 323. 8 cases are खाली से has to
कॉपी किसी देना है
26, 9, 25. That's it submitted 26, 10, 25.
My lord, the petitioner has only filed a comprehensive affidavit without any document that he is on bail.
So, no document.
No document.
Most of the cases of the 2018
verify
20
can discuss.
The Learning Council for the petitioner submitted that the petitioners are in judicial custody since 26/9/2025. And in the meantime, charge sheet has already been submitted and the offenses are triable by magistrate.
Yes, the one
Yes.
111 prove it as the organized crime.
So that is not triable by
Not triable.
except one offense, the other offenses are triable by magistrate. The Learning Council for the state has pointed out from the rejection order that there are a number of criminal antecedents against the petitioners. So far, to that effect, the Learning Council for the petitioners have filed comprehensive affidavit indicating therein about the status of those cases. And it is mentioned that the petitioner is on bail. Petitioners are on bail in those cases. The copy of the comprehensive affidavit has been supplied to the Learning Council for the state, who submits that since the petitioner is not filing any supporting document regarding the stand taken in the comprehensive affidavit that they are on bail, he may be given some time to verify this aspect. Put up this matter on such answer that this is taken on record. Yes.
Next sitting.
Yes, next.
Item 33.
Next sitting man.
Sitting কিছু নাই আজকে কোর্ট নাই বলে ମୁଁ পড়ছিলাম না কোন
My lord, petition is in custody since 6/8/25, my lord, and the alleged offence under section 25 of Arms Act. My lord,
type 1A. Prohibited act. Possession of prohibited act.
Two firearms and ammunition have been seized from the possession.
Yes.
One revolver and one pistol.
Punishment tribal by protection.
What about the criminal antecedents?
No criminal antecedent, my lord. And charge sheet has been submitted, my lord, since 3/10/25.
I have not received, madam.
The copy I have.
Yes, copy. That's
These the criminal antecedents. Have to obtain criminal antecedent. She of the accused has been verified. ଅଛି କି ନ ଅଛି କିଛି ଲେଖିନାହିଁ।
କିଛି ଲେଖା ହେଇନି
only CA of the accused verified ଅଛି କି ନାହିଁ କିଛି
ନାଇଁ ନାଇଁ ଭେରିଫାଇଡ୍ ଥିଲେ ଲେଖିଥାନ୍ତେ ସେଇଥିପାଇଁ
direct subject to verification.
ଯୋଉମାନଙ୍କର ଥାଏ ସେମାନେ ଗୋଟେ ଇଏ କଣ ଗୋଟେ ଫି ନମ୍ବର ଦିଅନ୍ତି ତାଙ୍କ ପ୍ରୋଭିଜନାଲ ଗୋଟେ କଣ କ୍ରିମିନାଲ ନମ୍ବର ନା କଣ ଏଇ ଟାଇପର
ଏଇଟା ଲେଖି ଦଉଛନ୍ତି।
To let him verify and if it is found that he is not the Learning Council for the petitioner, Learning Council for the state, considering the submission made by the Learning Council for the petitioner, that the petitioner is in judicial custody since when we were in
6/8/2020.
7/8/2025, and is aged about 22 years. And in the meantime, on completion of investigation, charge sheet has been submitted under section 25 bracket 1 hyphen capital A of the Arms Act on 4/10/2025. Copy of the charge sheet is filed and taken on record. And considering his further submission that the petitioner has got no criminal antecedent, and after hearing the land counsel for this case, I'm inclined to release the petition around the subject to condition that before accepting the bail bond, the land and court below shall verify regarding the criminal antecedent, if any, against the petition. And if it is found that the petitioner has got no criminal antecedent, then only the bail bond shall be accepted. And further conditions shall be imposed that the petitioner shall not indulge in any criminal activities. Yes, next.
Item 34.
May I please your lordship? This is a case under POCSO.
Notice.
So, notice.
Yes, kind of. Okay.
Item 35.
35 in sub-item I am appearing.
Commercial quantity mallet 20B280.
But sub-item, and the case there is there. Nothing was seized from my possession. I have annexed the certified copy FIR and also the seizure list, and case there is there. The 20 kg, 50 gram of ganja was seized from a bus from the driver.
That this is not there.
I guess it is sub-item.
No, past.
First time or record certificate. Case 11 minor kind of.
Second item था ना निहार रंजन महापात्र.
Page 11 one. 9th line from the top. After some time, the said blue balloon bus so and so came, and as we signaled, the bus stopped there. With the assistance of patrolling team, we checked thoroughly, and after verification of the rooftop, luggage carrier found a pink color jolly bag kept suspiciously covered with tarpaulin. On being asked, the bus driver Kalia Bariko, so and so of village so and so, disclosed it is given by one Nihar Ranjan Mahapatra of Raikia petitioner. After the bus reached at Bermuda bus stand, he will call to one Kanha and a state Kondhamal. And the seizure list, my lord, I have annexed at annexer 3, that is seized from that Kalia Barik. I was not there in the spot.
No, what about the criminal activity?
No,
I have to criminal accident, my lord. I have not obtained, my lord. I have to obtain criminal
The
accident.
Garden Council for the state submitted that though he has received the case diary, but he is yet to receive the instruction relating to the criminal antecedent. Place this matter on such and such data. If faster, so we think next.
Item 36.
The 6 Millers, registered tribal offences, custody, date Millers 12/9/2025, known affairs. On the basis of my implication in the conclusion of co-accused, and as revealed from the forwarding report, page 22 Millers, my total financial liability is 73,500.
Online fraud. 1 crore, 45 lakhs, 85,000.
Page 22, last
Cyber crime.
No, person CIDCB. Now the CIDCB investigation I have not received.
Oh, case diary not received. Adjourn next.
Item 37.
Allegation under section 318(4) BNS. Allegation is that the petitioner has taken 8 lakh rupees construction of boundary wall from the informant, and he has returned 50,000 rupees
to the informant. So both the petitioner and the informant are neighbors, and now they finally lost the affair that since 9/9/2025.
One criminal incident.
Earlier land counsel for the petition, land counsel considering the submission made by the land counsel for the petitioner, that the petitioner is in judicial custody since 9/9/2020, and the offense is triable by magistrate. And after hearing the land counsel for the state, submitted that the petitioner has got on criminal antecedent. I'm inclined to release the petitioner on bail allowed.
Item 38.
May I please, your lordship. Offense under section 20B to be, my lord.
10 kg
25
ganja.
25 naru custody 10 kg.
तो लिखा है 10 kg
12 at place 12 manner rejection order.
कस्टडी डेट के में
तो 25/9/25
25/9/2025 कस्टडी 10 kg ganja lesser than commercial quantity bar under section 37 applicable allowed.
Item 39.
Item 39, 40. Same accused, my lord. Total.
The 9 numbers of cases have been instituted against the present petitioner. The allegations are almost same. So let's see, we'll see the. I am placing item 39. Here the allegations are under section 318 for 420. I am saying it was the IPC section 420, 416, 467. But here they are stated that let's see the allegations. Chakiri koya koi ki poisa nahi. Out of 9 cases, this honorable court has granted bail to the present petitioner on 5 cases.
एक केस रे अमाउंट कितने
First case रे 4,79,900.
First case रे से कोई phone पे रे देची 37
deposit that amount in the trial court don't will not be paid, but it will be deposited. That would be the condition. What is the first case कितने amount 4 लाख का
Case तरीके से
4 लाख का
79,900.
Heard the land counsel for the petition and counsel for the state. Considering the submission made by the land counsel for the petitioner that the petitioner is in judicial custody since
Mera is in custody since 4/10/2024. In this case, he has taken on remand.
Has been taken on remand in this case since 4/10/2022. He was taken on remand in this case on 4/10.
No, he is in custody in 4/10.
After being taken into custody in another case on 4/10/2025. He has been taken on remand in this case after being taken into custody, judicial custody on 4/10/2024 in another case. And after hearing these offences are triable by magistrate.
Yes.
And the offences are triable by magistrate. And after hearing the land counsel for the state that this petitioner is stated to have cheated different persons and taken money from them on the ground of providing government job. And in the case in hand, the amount is rupees 4,79,900, which has been transferred to the account of the petitioner online.
No, online Miller, he is saying that 37,700 cash of rupees 4 lakh.
13ଟି କିସ୍ତିରେ ମୋଟ 4,79,900 ଟଙ୍କା online ମାଧ୍ୟମରେ ନେଇଥିଲେ. That is his allegation, whatever. And after hearing the land counsel for the state, I am inclined to release the petitioner on bail subject to deposit of the appropriate amount of cheating in the trial court. Yes, next.
Here, he stated that
submitted that the state submitted that there are 9 cases
My lord.
9 cases have been instituted, and the contention of the Land Council for the petitioner that 5 cases the petitioner has been released on bail. I'm inclined. So tell the amount now. In second case,
Second case, I have not received the case diary, but
No,
amount is
FIR
4,73,000.
so जो amount would have been allowed.
Milord, out of that, Milord, he has deposited, Milord, he is saying that, Milord, cash of rupees 3,35,000.
The amount of deposit for सब तरह trial court रे deposit करी bail जाते हैं. हासुरा लिखियो सब जहाँ same से एक का लोग होगा. This man is same in 39, 40, 41 and 42. है ना? Yes, next.
Next house 1,55,000.
Item 43.
तेरा लिखा है FIR रे. नहीं
तापरटा होचे आज्ञा सेथिरे आज्ञा ये रु रिटर्न करछि 20,000 मेलटा ऑनलाइन 1,27,000 and cash
42 sir 42 amount कितने
amount मेलटा 1,27,500 online and cash of rupees 2,29,000 3 lakhs
3 lakh और ये
65,800
8 कर दो
तादुरु कहूची मु 20,000 टका फेरी
20,000 टका फेरी लीजिए माइनस कर दो ये नेक्स्ट आइटम
Item 43.
अदर केस रे सब लखे टका हितला
43
41 I am 43. 43 petition authorization 6/9/2025 offenses on the sections 310(2) and 61(2)(a). There is no allegation against the petitioner.
42 रे आठटा आली
ने 43 not that. But the amount of
एरा बा डॉक्टर आई थी ना
आया 43 टा है.
43 is a case of 300
yes fellows 95.
So have you received the case diary?
No.
So CD and criminal antecedent. Yes. We think as you are तीनटा matter है. Next.
Item 44.
offenses under section
112 ग्राम बाउंस हुआ 112 ग्राम 42
अरे ना case diary नहीं. CD of criminal antecedent. Next.
Item 45.
Yes, 45. What is the offense here?
offense 10307 109 and other offenses are there 74 ଅଛି 76
You have received the case diary and the
altogether 12 injuries in different parts of the important.
What is the he has been discharged or still in hospital?
The discharge that's the thing.
I can see the charge sheet submitting. Like pass over. Yes, next.
Item 46.
This is not CD commercial one.
Yes, yes.
Is the अच्छी Mr.
Yes, ma'am.
Yes, CD available.
32 kg 800 grams.
Land Council for the state submits that the petitioner he has received the case diary and criminal antecedent instruction also you have got. No. And also the instruction about the criminal antecedent. Land Council for the petitioner 6 for an agenda that is to be listed with sponsor. Yes, next.
Item 47.
Thank you, yes.
Item 47. Allegation that the petitioners taking phone numbers of cow by walking. It's 12. Volume is custody since 15/9/25. खाली चाली की नहीं की जाऊ
habitually transporting the couch to.
No, my lord, there is no antecedent. And it's a class of the
Or the land council for the state, considering the submission made by the land council for the petition that the petitioner is in judicial custody since capital
15/9, 2020.
2025, and the allegation against the petitioner that he was taking 4 bullets, four bullets with him while walking on the street, and it is without any material. The prosecution has stated that he is transporting the animals, buffaloes, bullocks, for some other purpose. And after hearing the land council for the state, that he is smuggling the packages, inclined to release the petition. Okay, next.
Item 48.
I am Paranmela. All are valuable except 54 2 As per the allegation by the informant, the affairs of the informant and the petitioner arise out of the Facebook
123, 64, 115, 303, 35, and 66, 66, 67, 98.
123, 64 2M, 152, 032.
Have you received the case diary?
Minor.
So, what is the position now? Charge sheet submitted.
No matter charge sheet was not submitted, madam. In the petitioner is in custody.
What is the age of the victim?
The age of the victim is 30.
So, informant is a married lady.
Married. 164 section.
In the petitioner is unmarried, madam. 25 years.
Appears that they were kept relationship, and she went to hotel also. A number of occasions there was physical relationship, and because of those some nude photographs were taken and took some money. That is how the case ended.
As per the FIR story, madam, it is in custody 4/9/2025, madam. And in the FIR story, madam,
Or the land council for the petition land council for the state, considering the submission made by the land council for the petitioner that the petitioner is in judicial custody since
4/9/2023.
Investigation has made substantial proof, and it appears that the victim is a married lady, a consenting party. After going to the 164, this is the statement recorded under section 183 of BNSS produced by the land council for the state and other materials available on the. I'm inclined to release the the report of the doctor, wherein it is mentioned that the victim refused to get herself medically examined. I'm inclined to release the petitioner and be subject to condition that he shall not try to come in contact with the victim and appear before the learning trial on his death to the place of the procedure in violation of any terms and condition shall entail cancellation of the allowed.
Item 49.
May 69 and 81 of the BLS, my lord. Proceedings 69, 493. 493, corresponding to 493.
Sachi के statement of the in when you are in custody.
69 2025.
What is the age of the victim?
19 years.
He has not stated that she kept with any physical relationship. Though she stated that he insisted for physical relationship, but not stated that or the land council for the petitioner land council for the state, considering the submission made by the land council for the petitioner that the petitioner is in judicial custody since
So hold on.
9/2025. And when the charge is submitted or it is
No, man.
and the investigation of the case has made substantial progress and after going through the statement of the victim recorded under section 183 of the ENSS and other materials available and therefore I'm inclined to read the petition on the council for the petition and file the certified copy of the
Item 50.
Pick up the constructive graph. Search. Right. Notice.
Item 51.
The one alert is 29 kg not apprehended from spot alerts. 29 kg ganja not apprehended from the spot alerts, no antecedent.
Have you received the case diary?
No, madam, there is no case diary.
Get it. CD and criminal antecedent. Yes.
Item 52.
Hey, please. 55(1)(a) of the Arms Act. Custody since 14/9/25. Charge sheet submitted in the meantime. Allegation is that
there is no case diary.
only 25 Arms Act.
5 antecedent. 5 antecedent. The Reliance Council for the state submits that he has not received the case diary and pointed out from the rejection order that there are 5 criminal antecedents against the petitioner. Proof of this matter on such and such date, case diary shall be produced and the London Council for the petitioner shall obtain instruction relating to the status of the criminal cases and file a comprehensive affidavit in that respect. Yes, Arjan, next.
Item 53.
May I present a similar? 67 Lord 66 of ITS custody Lord none of 2025 charges submitted. Here is a case Lord for a moment look into the statement of the informant. He stated that Miller his niece had talking term with the present petitioner. When Miller he opposed this said Miller talking term and got Miller vexed on the present petitioner. He, due to anger, Miller posted a edited photograph Miller of his niece in a Instagram ID ଓଡ଼ିଆ ଗାର୍ଲ ଆମର କିଛି କେସ୍ ନାହିଁ ଏଇଟା ଇନଫର୍ମାଟିଭ ଷ୍ଟେଟମେଣ୍ଟ
354A 292 and 507 67 68
ଆଜ୍ଞା
BNO sir.
ଗୋଟେ ଏଡିଟେଡ୍ ଫଟୋଗ୍ରାଫ ଫଟୋଟା ଖାଲି ଗୋଟେ ସେଣ୍ଡ କରିଛି ଇନଷ୍ଟାଗ୍ରାମ ଆଇଡି but previously in his statement the informant alleged that his niece was talking term with the present petitioner and they frequently talk to each other when he opposed this said relation. आगे की
Ordinary counsel for the petition and counsel for the state say another statement. The learning
informant
petitioner filed the statement of the informant which is taken on record. The
forwarding the statement of the informant.
9920. After hearing the land counsel for various parties, considering the nature of accusation against the petitioner, the age of the petitioner, the period of detention in judicial custody, the progress of investigation, and inclined to release the petitioner on bail subject to condition that he shall not try to come in contact with the victim and shall not indulge in any criminal activity or tamper with the evidence, appear before the land trial court on the state for verification of the posters, violation of any terms and conditions or entail cancellation of it allowed. Yes.
Item 54.
May I please, Your Lordship? Lordship, 153 liters of ID liquor
153 liters of ID
in custody since 26 September 2025.
On the land counsel for the petition, land counsel for the state, considering the submission made by the land counsel for the petitioner, the petition leading judicial custody since 26/9/2025. And offense is triable by magistrate elders after hearing the land counsel for the state and for the taking into account the age of the petitioner, I am inclined to release the petitioner on bail allowed.
Item 55.
My Lord, 9.5 kg of contraband ganja in custody since 24 September
9 kg 500 grams.
What is the custody, madam?
24 September 2025.
24 September 25. 9 kg 500 grams, lobster grams, and bar and the second allowed.
Item 56.
My Lord, 8 kg ganja
8 kg of ganja
in custody since 25th September 2025.
Item 57.
May I please, Lordship? On offense under section 69-51(3) of BNS, my lord. And the informant is a married lady,
false promise to
aged
marry,
about 31 years.
false promise to marry and physical relationship.
What is the
My lord,
statement of
my lord, direct statement marriage.
Or the land council for the petition and land council for the state. Considering the submission made by the land council for the petitioner that the petitioner is in official custody since state 2025. And in the meantime, completion of investigation, charge sheet has been submitted under section 69 and 351(3) of the BNS. The going through the statement of the victim recorded under section 183 of BNSS and other materials available on record produced by the Learning Council of the state and inclined to release the petitioner on bail subject to condition that the petitioner shall not try to come in contact with the victim and temporarily be released and it shall appear before the learning trial from each state which the case of the posted violation of any terms and condition shall enter cancellation of bail allowed.
Item 58.
Yeah, please, Allah. Petition number 1 is the informant, and the petition number 2 is the friend of petitioner number 1. But they are implicated in an offense under say 126 to 127 to 296, 115, 118, 109, 75, 76, 333, 351, 2 of the BNS Act matter are there in custody since 9/9/2025.
354 351 307
307 injury is simple in nature. Your lordship may kindly see. While the petitioner, petition number 1 found that the informant along with another person was inside the room. There was a quarrel. And subsequently, the incident was occurred.
It's not if both you have done this thing, entered inside the house and committed all this thing.
Admittedly, the informant is the wife of the petitioner number 1, and due to the extramarital relationship with one Vishnu, there was a disturbance, and the petitioner.
So you came with another person and committed this crime.
No, my lord. It is alleged that while he went to the house to saw his son, he found that the lady was the informant was inside the
Doing that criminal antecedent.
I have no criminal antecedent. My lord, I am a lecturer in a college, my lord.
Next.
Item 59.
Yes, my lord.
my lord.
On behalf of Mr. J.N. Panda, I pray for an adjournment.
The case very
My lord. 302 my lord, there is no case date.
TV and criminal antecedent.
Item 16.
Yes.
System 26 kg of ganja kg.
But I am praying for to be had in the but I mean pardon. In the state of Govardhan Patnaik, I'll kindly glance to page 10.
Let him bring the case there. Yes, next.
61.
And the petitioner is in custody since 14/7/2025 and the alleged offences under section 64 64 of PNS and other allied offences. In the meanwhile,
376 is there, man. 376 is there.
First on that victim statement. The gang rape,
no,
both have participated. First, somebody committed rape, and then again this.
But in the FIR and other material shows that my lord, only the petitioner is in one case.
No, this 164 is stated.
Sorry, I don't have that copy.
Criminal and instance.
Okay.
Item 62.
Here, my lord, the petitioner is in custody.
There is no surgery matter.
CT and criminal and instance. Yes, next.
Item 63.
May I please? There are three bail applications. In first bail application, they have been entailed in this case by co-accused statement. My instruction is that so far as the allegation is 51.
You obtain that criminal antecedent?
Criminal किसी नहीं है किसी.
Yes, next. CT and criminal antecedent.
Item 64.
May I please? 6% planning the docket. A charge sheet already filed. Two co-accused religion will. Rajiv Bachchan and Sanjay Dale.
Be little louder and clear. What is your submission?
6% planning the docket.
Yes.
2% already religion bail.
Who has been granted bail?
Sanjay Dale and Rajiv
Where is
Bachchan.
bail order copy?
And the district and session judge.
So why your bail application was rejected? If they have been granted bail, why your bail application was rejected? What is the difference between you and those two co-accused persons? What was seized from your possession?
Life. Churi bottle empty. No criminal antecedent. Petitioner number 1.
402. And then criminal antecedents are there.
No.
How many cases, sir?
No.
This man is Vishwanath Das.
No criminal antecedent.
No shit. He has
No
no
shit.
criminal.
But the Land Council for the Petitioner Land Council for the state, considering the submission made by the Land Council for the petitioner, that the petitioner is in judicial custody since 25/8/2025. And is a young boy is at about 20 years and having no criminal antecedent. And some of the co-accused persons have already been granted bail. And after hearing the Land Council for the state, I am inclined to release the petitioner and bail allowed. What about the other persons?
Other criminal antecedent there.
No. One criminal antecedent. S.K.Sahoo. One criminal antecedent.
All were in that spot.
Yes, madam.
Taken into custody. The state council submits one criminal antecedent, but bail is allowed.
Two criminal.
Sheikh Arif.
ସେ କ୍ୟାରିପୁରେ ୱାନ୍
ନା ଟୁ
Sheikh Arif na kitna?
ଟୁ क्यों
Two criminal officers. Bail allowed to appear before the police station, for 3 months. So once in a week and petition there. Yes, next Sheikh Samraj.
Samraj.
Samraj Mysore 3 at
3 aunties.
3.
PCA, bail allowed and appears and next.
Next my lord,
One criminal.
Shanto. No 3.
No.
3.
3 criminal.
Bail allowed, 3 criminal entities appear before the police station. Yes, next.
Item 65.
65.
ये मेरा पोस्ट आर्टिकल है अच्छा
Okay. Next.
Item 66.
Yes, 66, I have to obtain the charge sheet by lot 395.
PI पर identifies in 45,000 recovered.
If urgent is, I will obtain the charge sheet.
The land council for the petitioner 6 for an adjournment. Land council said the state submit that he has not received the case diary as well as instruction relating to the criminal adjournment. Next.
Item 67.
May I please your lordship, the petitioners were apprehended by RPFS Baleswar Miller on the
cocktail seized. Cocktail seized.
point.
The prohibited area to say need
Have you got the case diary?
No.
Criminal admission.
Item 68.
Case posted in 15/10/2025, my lord. That injury report is there, my lord. One is grievous injury, fracture injury, and it is grievous, my lord.
Who is in you?
That in front.
No, Nada.
Vijay Kumar Singh.
He has sustained
Grievous things at page 30.
Fracture injury at page 13, my lord. Case countercase due to that passing of battery water that
when you are taking
15/10/2015. Earlier, filed the accident because this one report and it was implemented of the thereafter the direction of the first or second or surrender and
that man who has sustained grievous injury has he been discharged from the hospital?
Right.
Yes, charge is submitted.
Dispute between the two neighbors, my lord, for the passing of battery water. Counter this is there, my lord. First, they
Vinod Rai the tinita criminal antecedent. Vinod Rai. Vinod Rai petitioner. Khetrajpur PS case 229.
As they attack the family of the present petitioner, thereafter counter objection. Attack it.
Or the Land Council for the petition Land Council for the state. Considering the submission made by the Land Council for the petitioner, that the petitioner is in judicial custody since 15/10/2025. And it's a case and counter case. And though the informant is an injured, sustained grievous injury, but he has been discharged from the hospital quite well and happy. And after hearing the Land Council for the state who submitted that the petitioner has got some criminal antecedents and going through the comprehensive affidavit filed by the petitioner. What has happened in this case?
Pending,
Pending one, no, bail on bail, and stated that the petitioner is on bail in all those cases. I am inclined to release petitioner on bail subject to condition that before accepting the bail, the London Court shall verify the bail orders in all those cases. According to you, how many cases are pending? Three cases are pending. Yes.
Item 69.
Item 69.
May I permitted to be filed better application?
File a liberal none.
Lordship, I'm paying my lord. The order dated 26/9/2025 kindly be directed to
the Mr. Mahapar from Land Council for the petitioner files the application for withdrawal of the bail application and submits that the free copy of the better application and submits that the free copy of the ejection order which has been annexed to the bail application as annexure 2 may be returned to him. Let the registry return the same on being substituted with a Xerox copy. Yeah. Bail application is disposed of with a name and similar. Yes.
Item 70.
9 kg. 9 kg.
From 2 accused persons, it is alleged that 9 kg of custody 13/9/2025.
13/9/2025. 5 kg.
9 kg.
9 kg. 37/5.
Item 71.
71, please, also. The present petition is in custody since 5/9/2025 and of allegation under section 318 subsection 4 and 316 subsection 5 of the BNS. And
2,49,633 टंका.
Yes.
Without preparation.
What
is the amount?
Private. 2,49,633.
73. And all the offences are tribal by magistrate.
Or the London Council for the petition and council for the state considering the submission made by the Land Council for the petition that the petitioner is in register since 5/9/2025 and offences are tribal by magistrate and amount involved is around 2,50,000 and taking into account the progress of investigation.
It's charge sheet already submitted.
Yes. And taking into account the submission that charge sheet has already been submitted. After hearing the London Council for the state, I'm inclined to release the petitioner allowed.
Item 72.
Section 6
is there.
Item 73.
500 kg. 5 kg गंजा.
Where is the council? Next.
Item 74.
My lord, custody since 29/25, my lord, 3 Act, earlier rejected 14/7/25, no criminal accident. My lord, charge sheet already submitted, charge already framed. My lord, victim is mentally retired, suffering from defender and dumb. My lord, 3 Act.
Item 64.
74 ये वाली submission.
74 my lord item.
Yes, yes.
My lord, custody since 29/25.
Retired person, handicapped lady.
Charge already my lord framed.
It's 60 access.
No criminal action my lord.
Yes, yes, yes.
Yes, yes, no notice. 73 टा pass हो 74 टा कर देंगे since one of the offense is under section 3 of the SC/ST Act notice Accusal of the next.
Item 75.
May I please your lordship, madam? 20B2C, 24 kg of ganja.
अच्छी की CD and criminal assessment.
Item 76.
8 kg 380 grams. Custody since 14/10/2025. 14/10/25 and 8.388 kg ganja lesser than commercial quantity bar under section 37 not applicable allowed. Okay.
Item 77.
27302 taken up Saturday to go to the CD receipt.
And counsel for the state submits that though he has received the case diary but has not gone through the same and the same may be taken as next week. Is this matter next week we could be assigned.
Time.
Next week time. Same date.
Item 78.
Yes, yes, lot 78. Lot 78 is 115 along with 351, 324 and 25. I'm certain also. Lot 78.
The rejection orders, there are some criminal antigen at page 19.
Also, petitioner have just only 2 criminal.
So we have to call for that.
There is no injury lordship. FR and counter FR is there lordship. This Hon'Ble vitre lordship.
Understand he blows and splitting on his face. These things on. Case and counter case.
Lordship. This Hon'Ble vitre
Since when you are in custody?
cost.
So
Custody since 16/9/2020.
Now, the land council for the petition land council history. Considering the submission made by the land council for the petition, so the petitioner is in judicial custody since 16/9/2025, and investigation has made substantial progress, and the petitioner and the injured are related to each other. And after hearing the land council for the state, I am inclined to request the petitioner to be allowed next.
May I please your lordship? During this the charge sheet submitted for the offense 376-2N, my lord.
372N.
अच्छी case value थी. I should from the statement of the victim. But the what's the victim the statement?
Victim statement.
Clear. From the town number from the value. କାହିଁ ରଖୁଛନ୍ତି କଣ ପାଇଁ ସେ ତ ଆଣି ଦଉଛନ୍ତି
ସେଟା ଅଫିସରେ ଦେଇ ଦେଇଛନ୍ତି
କିଛି ଦେଇଛନ୍ତି ମୁଁ କହିଥିଲି ସେଟା ତା ଗୋଟେ ବସେଇବା ପାଇଁ ଚେକ୍ କରିବି ନହେଲେ ଯିଏ ରିସିଭ୍ କରୁଛି ତାକୁ ପଠେଇବି ସେ ଥାନାକୁ ଯାଇକି ନେଇକି ଆସୁଛି ଏଜ୍ କେତେ ବା ଭିକ୍ଟିମ୍ ର
Victim 26 years.
ସ୍କୁଲ ପଢିବା ସମୟରୁ ମୁଁ ତା ସହିତ ସମ୍ପର୍କ ରଖିଥିଲି ଅଲଗା ଝିଅକୁ ବାହା ହେଇଯାଇଛି କେବେଠୁ ରହିଲେଣି?
My lord, since 24/4/2025. There is a love relationship since
Council for the petition and council for the state. Considering the submission made by the land council for the petitioner, that the petitioner is in judicial custody since 24/2025.
my
And charge sheet has already been submitted under section 376.
2N.
After going through the statement of the victim recorded under section 180P, BNSS, and other materials available on record, which is produced by the land council of the state. And inclined to believe the petition, they will subject the condition that the petitioner shall not try to come in contact with the victim. That shall not try to tamper with the evidence, no? And shall appear before the learning trial court on each state to which the case shall be posted. Violation of any terms and conditions shall entail cancellation of bail.
अच्छा
Yes.
Item 80.
80 में please that's 20 kg
12 kg गंजा
हाँ,
12 kg गंजा
Repeat why नहीं
25 9 25
25/9
I guess
25/9/2025
I have one and
quantity ହଉଛି 12 kg କୋଉଠି ଅଛି ଲେଖା ହେଇଛି
yes
rejection order
12 kg ଗଞ୍ଜା lesser than commercial quantity ये लगा
Matlab I have one antecedent I have one antecedent
submitted that he has got one criminal antecedent ये लगा अब बाकी तो launch for another
My lord, I may kindly pardon to make a mention, my lord. Item number 105. I may kindly permitted to withdraw.
105 there are two bail applications.
Two memos I have filed.
Memo taken under disposal.
166 my lord permitted to withdraw that premeditation jota thila they have already compromise matter and complaint of paisa ki the case sorry sir
100
166 kali jota premeditation re thila aji ki
166 files a memo. Withdrawal of the CRLMC, disposed of as withdrawn. Interim order stands vacated. Communicate the order to the learn and trial court. Allah.
Item 81.
Your Lordship, on behalf of counsel Advocate Saroj Kumar Padi, I seek for an adjournment because his
What is your good name, ma'am?
Your Lordship Shejal Harichandan.
You have received the case diary?
My lord, case diary that 20B 130
CD and criminal antecedent and learn counsel for the petition of 6 for an adjournment. Yes.
Item 82.
Pleasure, lords. Petitioner is a lady, my lord. In 60 grams of brown sugar was seized. Almost 2 months have been custody. 37 is also not normal. Custody from my lord 24/9/2025.
And counsel for the state, considering the submission made by the counsel for the petitioner. The petitioner is a lady and she is in judicial custody. It's 24/9/2025. And investigation. That PR has been submitted.
From C5 I have annexed didn't
Investigation has made substantial progress and the quantity of the brown sugar specifically has been seized from possession of the petitioner was 60 grams, which is lesser than commercial from the 37 is not applicated. The hearing will land counsel for the application is allowed. Yes.
Item 83.
May I please mercy? The complaint from deceased died after 2 months. And he himself was lost the affair.
103 is there.
I am giving the statement of the deceased.
BNS CD not allowed.
No antecedent, yes.
Lord, I may pardon. If possible on Friday.
With item number 84. 84.
Yes. In this case, as a petitioner 1 to 7 were involved in the commission of offence under section 109, 15, 115 to 96, 35 BNS. Thereafter, the petitioner, after this case, the petitioner approached before the Hon'Ble High Court and filed ABLPL number 8533, in which the Hon'Ble High Court directed to surrender before the learned court below. And thereafter, the petitioner surrendered before the learned court below. But your lordship, the petitioner 1 was granted bail out of 7 petitioners. Lordship,
Who antecedent is there?
I am for the informant in this case, my lords. Lords, altogether there are 4 injured persons, out of which, my lords, 3 have sustained grievous injury on vital part like head, my lords. I have document with regard to 2 injured persons injury, my lords.
You are already discharged, Excellence. You are in custodian frame. 1710.
Yes, my lord.
All of you surrendered after as per the order of this court.
Yes.
yes.
देखिए कौन सी? There are 4 injured persons.
My lord, I have copies of injuries in respect of 2 injured persons, my lords, which I have supplied.
Already. Out of them, how many of them have sustained grievous injuries?
Lords, as per my instruction, 3 my lords: Sanjay Kumar Behra, Uday Bhanu Behra, and Santosh Behra.
Heard the land council for the
Lordship, this is a council
for the state. The land council for the petition submitted that as for the order filed by this court in the BLAPL number 8533 of 2025. And CRMC number 3771/2025. The petitioner surrendered in the court below and moved an application for bail, which has been rejected. It is further stated that they are in custody since 1811.
17/10/2025.
अच्छा 17/10 ना 18/10 17/10 17/10/2025 and it's a case and counter case and the injured persons have been discharged from the hospital and they are quite ill and fatigued. And investigation has also made substantial progress, and therefore the bail application may be favorably considered. Land counsel for the informant opposed the prayer for bail and filed the injury report of Sanjay Kumar Behra and Idhot Behra, and submitted that in this case there are 4 injured persons, out of which 3 have sustained grievous injuries.
For the patient 1 is considered that 2 antecedents.
The injury reports filed by the current counsel for the informant are taken on record. And counsel for the state also opposed the prayer for bail and submitted that the petitioner number 1, Gyanendra Das, has one criminal antecedent.
So petitioner 5 has 3 antecedents.
Considering the submission made by the land counsel for the respective parties' nature of accusation against the petitioner, since it's a case and counter case, and taking into account the progress of investigation and inclined to release the petitioner on bail subject to condition that they shall not indulge in any criminal activity and shall appear before the learning prior from which the case will be posted. Violation of any terms and conditions. Cancellation. What is your good name, land counsel?
Lord Sumit Sir Patnaik, S.S. Patnaik.
S.S. Patnaik. Yeah.
Lordship. May I permit it, Lord? So, Lordship may reflect petitioner 5 has also cases 3 as per as to
he informant of submission and liquidation. Petition number 5.
Ranjan Behra.
Ranjan Behra has got
3 criminal incidents.
All right. Yes, next.
Lordship.
Item 85.
Where is it? 3094, my lord. In this case, the present petitioner has been remanded.
Yes.
So, in the present case, the petitioner has been remanded, my lord. Basing upon his own confession, he was arrested in another case in which he has been identified. And in this case, he has been remanded.
Yes, sir.
Yes, there is a 13 antecedent is there.
ଗୋଟେ କେସରେ ଆରେଷ୍ଟ କଲେ ଆଜ୍ଞା ସେମ୍ ଡେରେ ଆରଟା କେସରେ ରିମାଣ୍ଡ କର ମୁଁ ଲେଖିଛି ମୋ
The land counsel for the case has obtained inquiry and submits that there are 15 criminal antecedents against the petitioners. Let the land counsel for the petitioners obtain instruction in respect of such antecedents for the status of the criminal cases and file a comprehensive.
Petitioner 2 is a 17 criminal antecedent, 1 is a 13 antecedent. There are 2 petitioners. One have a 13 antecedent and 2 has a 17 antecedent.
1 plus 13 and 2 are 7. Yes. One week after it will come. Yes, next.
86.
86 May 6. And see the petition custody since 29/9/2025. 45 liters of idle liquor, contaminated liquor.
What is your custody date?
Custody date is 29/9/2025.
Counsel for the petitioner and counsel for the state. considering the submissions made by the land council for the petitioner, that the petitioner is in judicial custody since 29/9/2025, and the offense is triable by magistrate. Investigation has made substantial progress of the hearing. The land council for this case, I am inspired to the case with petitioner. Next.
Item 87.
Oblations.
May I please, Your Lordship, offences under section 465, 467, 474.
87 minutes. I place the city is not available in the Bangladesh. They are making the fraud documents, so I place some time to the call for the.
You have not obtained the case.
Okay, do not have.
And let's see the criminal antecedent on it.
Item 88.
So is there?
Lordship, section 6 POCSO notice to go.
Yeah. You have obtained the case.
STD is available.
CD is available for like that.
Item 89.
59 the present petitioner has been implicated along with her husband, my lord. The husband has purchased wheat from the informant and paid some amount, and some amount is pending outstanding. (318.2) and 318.4.
What is the allegation?
Allegation the present petitioner along with her husband (9 lakhs) as per the informant FIR, my lord. And rest amount is 26,97,000.
These are tribal magistrate.
My lord, tribal magistrate, the petitioner is the lady, my lord.
When she was taken into custody?
She was taken to custody, my lord, on 22/9/2025.
Yes, Mr. Ryan. How the General Counsel for the petitioner and counsel for the state, considering the submission made by the land council for the petitioner that the petitioner is the lady and she is in judicial custody since 22/9/2025. The offences are tried by magistrate and husband
is the custody.
And the main allegation is against the husband of the petitioner. But you have mentioned that she is the daughter of Sadhana Pradhan.
Priti Khora এবং ତାଙ୍କ ସ୍ୱାମୀ ଲେଖା ହେଇଛି।
ଆପଣଙ୍କର first title ଦେଖ।
Cost ସେଟା rejection order ଯାହା ଲେଖା ହେଇଥିଲା ସେ ତାକୁ
But Sadhana Pradhan is the
Sadhana
Pradhan is the
father of the
husband of his petitioner.
Sadhana Pradhan ତା ବାପା। FIR allegation ହେଲା ତ ସ୍ୱାମୀ ନାହିଁ। Rejection order ରେ daughter of ଲେଖି ଦେଇଥିଲେ ସେ ବାଧ୍ୟ ହୋଇ ଲେଖିବାକୁ।
ତା ସ୍ୱାମୀଙ୍କ ନାଁ କଣ? Yes, Mr. Swami Nago. In the FIR also it is mentioned that we can search that. And the husband. I'm inclined to release the petitioner on bail. The charge sheet has been submitted. By petitioner shall cooperate with investigation. Shall not try to temporarily gain. Yes.
Item 90.
May it please,
My lord, offences are under section 126 to 296, 115 to 118, 119(1), and other available offences, my lord. The petitioner is in custody since 26/8/2025, my lord. Lordship may kindly glance the NDU report, my lord. NDU report, Lord Session Judge also elaborately discussed. Lord, so I have also certified copy. He has a discharge certificate and also filed a comprehensive affidavit, my lord. Lordship may kindly glance. So far as the allegation is concerned, while the elder brother of the informant was returning from Rasulpur, the accused Dipu Malik assaulted by sharp cutting weapon, and petitioner, my lord, assaulted gave a blow to his left leg, my lord. So far as the petitioner is concerned, my lord. And they allege that the accused person took away rupees 30,000, gold ring and mobile, my lord. I have given certified copy of NG report and learned session judge also observed. First Medical College, thereafter Fakir Mohan Medical College and Fisa Hospital. He has been discharged. IO has been seized, as it is mentioned in the rejection order also.
Have you obtained the injury report?
My lord, I am referring for the sub item, my lord. In my petition, my lord, I filed the injury report, my lord. Annex 4, my lord.
That is the injury report.
Injury report as well as the discharge certificate also, my lord.
Lord Session Judge also mentioned, my lord.
Which is your item?
My lord, 1126, my lord, 4020. Second.
No, same deal, sir.
Yes, ma'am. Annex 4.
Page,
discharge certificate is also annex.
Page 13, 14.
In my case, my lord, my name is not in the affair, my lord.
Wait.
My injury report is not available.
Lord Session Judge also mentioned, my lord.
Second case. And rejection order also indicate what are the, he has mentioned in detail.
Details.
Main injury seems to be on the head, left temporoparietal region, and the allegation against so far this petition is concerned that he assaulted on the legs.
Leg, my lord.
Are the learning counsel for the petitioner and counsel for the state. When counsel for the petitioner submitted that the petitioner is in judicial custody since 26/8/2025. What about the submission of charge sheet?
Charge sheet, my lord,
Not
3 months.
No instruction.
No instruction, my lord, 26/8. About 3 months.
And investigation has made substantial progress. The further submits that the injured in this case is one Ramakant Mahali. And in the prosecution case, that the petitioner dealt blows to the left leg of the injured. And the main injury has been caused on the head of the deceased by the accused. He further submits that the injured has been discharged from the hospital. And
On the 16th of September.
Therefore, the bail application may be favorably considered. He has filed the injury report, which is taken on record. What is this
comprehensive affidavit, my lord, involved
Type affidavit there.
the learning counsel
294 506.
The learning counsel for the state opposed the prayer for bail on the ground of criminal antecedents against the petition. The learned counsel for the petitioner has filed a comprehensive affidavit relating to the indicating that in all the cases the petitioner is on bail. The comprehensive affidavit is taken on record. So also the injury report, certified copy of the injury report. Considering the submission made by the land council for the respective parties, the nature of oversight attributed against the petition is of detention and judicial custody, and inclined to release the petitioner on bail subject to condition that he shall appear before the IAC of Hon'Ble police station once in a week on every Sunday in between 10 to 4 for a period of 3 months, and shall also appear before the land and trial court on each date to which the case will be posted. He shall not try to tamper with the evidence or indulge himself in any criminal case. Violation of any terms and conditions of cancellation allowed.
I am in custody since 26 September.
You are the main assailant, right?
No, my name is not in the FIR, my lord. But even, my lord, I have annexed the, my lord, informant statement also, my lord.
Yeah.
The informant not stated anything against me, my lord. The 3 persons have asserted the,
Your name is Pinku.
Pikun, my lord.
Pikun.
Putivas
Pikun
Malik
alias-
Pikun.
Putivas.
Putivas Malik Pikun.
His name is not there in the FIR.
Yes, my lord.
What about the in the statement? It is there.
No, in the informant statement, my name is not there. But
Okay.
one Rilochan Malik, my lord. Rilochan Malik. Troilokya Malik, my lord. Annexer 3 series, page 18, my lord. Troilokya Malik. He only stated that I am present there. My lord. In the informant
Second
statement,
hour 11264. Where is the statement?
my lord, Annexer 3,
Page.
my lord, page 18, my lord.
ଆପଣ ନାଁ ଅଛି
ସେଥିରେ ଅଛି।
Seventh line.
ଓରଫ ପୃଥିବାସ ମଳିକ।
ପିକୁନ alias ଓରଫ ପୃଥିବାସ ମଲ୍ଲିକ ଲେଖା
ସେଥିରେ କିନ୍ତୁ ଏଫଆଇଆର ନାଁ ନାହିଁ। ଆଉ ପେଜ 19 ହେଲା ଇନଫର୍ମାଣ୍ଟର ଷ୍ଟେଟମେଣ୍ଟ। ଇନଫର୍ମାଣ୍ଟ ଷ୍ଟେଟମେଣ୍ଟରେ ଆସଲ୍ଟ ପାର୍ଟ ମୋ ନାଁରେ ନାହିଁ କିମ୍ବା ମୋ ପ୍ରେଜେନ୍ସ
the or the land council for the petitioner and council for the state. Land council for the petitioner submits that the petitioner is in judicial position 16/9/25.
Subhash Behera's statement ଅଛି
And investigation has made substantial progress, and though the though the first information report indicates the name of as many as 6 accused persons, but the name of the petitioner doesn't find place in the first information report. Even the first informant statement also not named the petitioner as an accused. However, one Troilokya Malik has named the petitioner along with the co-accused persons who have participated in the assault.
Subhash Behera,
Land
Malik,
council for the state power submits that there are other witnesses also who have implicated the petitioner as the assailant of the injured. Considering the submission made by the land council for the petitioner, the nature of overtake attributed against the petitioner, and period of detention, the petitioner in judicial custody, I mean, the petitioner on bail, see condition of the hearing.
Item 91.
May I please allow? My lord, petitioner is in custody since 11/9/25, my lord. The alleged offences are 331(4), 305E, 61(2), and 35 of BNS, my lord. Corresponding offences are 380, 457, 120B, and
457,
380, my lord. My lord, allegation is that Some machineries were stolen from the laboratory of NCL, my lord. And those stolen articles have been recovered from one Mohammad Afiq Ansari, who has been granted bail by your lordship in BLA bail number 10709.
Mohammad Ansari.
Yes, my lord. Mohammad Afiq Ansari.
Aji thila.
No, my lord, that order dated 31/10/2025.
Copy of that order.
Yes, my lord. The charge sheet has also been submitted, my lord, and
Or the learned counsel for the petitioner and learned counsel for the state. The learned counsel for the petitioner submits that the petitioner in judicial custody since February
11/9/2025.
11. And in the meantime, completion of investigation, charge sheet has been submitted under section 331 bracket 4, 305 bracket E, 61 bracket 2, and 3 bracket 5 of BNS. He submits that the stolen articles have been recovered on the possession of one Muhammad Afiq Ansari, alias MD Afaq Ansari, who has been released on bail by this court in BLAPL number 10709 2025 as for order dated 31/10/20. Therefore, bail application of the petitioner may be favorably considered. He files the copy of the bail order which is taken on record. Land counsel for the state opposed the prayer for bail and submitted that from the CCTV footage, the identity of the culprits could be established, and the properties were stolen from the laboratory, and the estimated cost is around 70 lakhs. Considering the submission made by the land counsel for the respective parties, the nature of accusation against the petitioner, and the release of the co-accused persons on bail, co-accused on bail, and the period of detention of the petitioner in judicial custody. I'm inclined to release the petitioner on bail alone. There is any criminal antecedent?
No, it is no CBI.
Absence of any criminal antecedents. Yes, next.
CBI has not.
Item 92.
Well, item 92.
92. Originally 363 register, now turn.
My lord, I am withdrawing this application with a liberty to file better application, my lord. Lordship may direct to return my certified copy of the rejection order dated 4/6/2025. Annexed.
6 for withdrawal of the bail application to file a better one, and he also pays for return of the certified copy of the rejection order, which is annexed to the application as annexed to. In view of such submission, the bail application is disposed of as withdrawn. The certified copy of annexed to be returned. The petitioner's counsel on being substituted with thereof. Yes.
Liberty may be granted.
That is of that I have stated that you are liberty to withdraw to file a better application. Yes, next.
93.
May I please? 2096, my lord. The allegation is that the petitioner, along with others, they took away cash of 20,000 along with mobile and some documents from the informant.
The charge sheet has already been filed, my lord. The petitioner is inside custody. Hence, my lord, his date of arrest, that is, my lord, 22/2025. 22/2025. 22/2025. And charge sheet has been submitted.
Charge sheet under what offense?
Charge sheet under 3096 and 35. This is the copy of the charge sheet, my lord.
Hey. Magistrate law.
My lord.
What do you say, Mr.
The petitioner therefore that some other cases are perhaps in the history sheet, that is petition history. So see, if there is no other antecedent, CA is required. Page 12. It is found that petitioner is a history seeker and committing similar nature of crimes.
The land council for the petitioner and council for the state, considering the submission made by the land council petition that the petitioner is in judicial custody since February 22/2025, and in the meantime, on completion of investigation, charge sheet has been submitted under section 309. That was 6. Now, he rectified filed. Copy of the charge sheet is filed and taken on record. And after hearing the land council for the state who submitted that the petitioner has got criminal antecedent and in time to release the petitioner on bail subject to condition that he shall appear before the IAC of Old Pariguda police station once in a week and additionally in return came to court for a period of 3 months. We are not indulged in any criminal activity to allow. Document is charge sheet देगी बात में. उनका document सब हो चुका है, charge sheet देगी. Yes, ma'am.
Item 94.
Lordship. Alleged offense against the petitioner lordship 302 and 34 lordship. And the petitioner
Received the case diary.
Some of that day because the statements are not legible. Right paper next week only.
The land councils of the state submitted that he has received the case diary, has not gone through the same, and the matter may be taken up next week. List this matter next week. Yes.
Item 95.
Yeah, lordship. Offense on 20B2. We have indicated 10 kg 20B2B. 10 kg of ganja has been seized from the possession of the present petitioner.
10 kg.
10 kg.
What is your custody date?
10/10/2025.
10
10/10. 10/10/2025.
10/10/25. 10 kg of ganja lesser than commercial quantity, bar not applicable, allowed next.
Item 96.
Please, Your Lordship. The petitioner is in custody since 11 September 2025 for the commission of the offense under section 20B, clause 2B of the NDPS Act. The allegation against the petitioner here, Your Lordship, the illegal transporting of 8 kg down. 8 kg of ganja, Your Lordship.
11/9/2025, 8 kg ganja lesser than commercial. Their application is allowed. What is your good name, madam?
S.K.Sahoo.
Give that now.
I have power in this case.
Give your name in full so that it can be reflected. Yes.
Item 7.
उसको आप लीजिए. उसको मालूम हो रही है.
No, it is good.
Noted. 4 and 18 not request.
Item 98.
Withdraw this bail application was reported to accused man on the court below after submission was received. And the trial court matter, the trial court take into consideration to the petition on a priority basis in BL below 218 by condition of taken on record before the what can say? Yes.
Item 99.
99.
6 of the POSCO Act. 99 million, 6 of the POSCO Act. Along with all this.
Page apology. The trial court take consideration.
Shorted minute.
No necessary to mention all those things.
99.
Move it. If you stands on a similar footing, is to consider it. There is no necessity of mentioning it. Yes. Item number.
Item 100.
kg of commercial quantity. Have you got the case diary?
No, madam. No, madam.
They gave you CD and Kimball antigen. Yes.
Item 101.
No, there is some crossover matters.
Passover item number 45.
You have received the case diary? Yes. No, whatever. Look on. Learning counsel for the state submits that he has received the case diary. None appears on replicate. Case is urgent. Yes, next.
Item 73.
73. Sachidananda Padhi.
5 kg ganja.
But he is not appearing. What can be done? Land counsel for the petitioner is not present and repeated for case is urgent. Yes,
On behalf of Mr. Sachinanda Padilla. On behalf of Mr. Sachinanda Padilla.
What do you say? Urgent?
No.
आपको कहते ना से 5 kg गंजा सुनला बेलू उठी पड़ले
ନାଇଁ ମତେ
କହିଥିଲେ ଭୁଲିଗଲେ
ଆଜ୍ଞା
ଦେଖନ୍ତୁ କଷ୍ଟଡି ସିନ୍ସ କେବେଠୁ ରହିଲେଣି 9925 9925 5 kg ଗଞ୍ଜା lesser than commercial quantity allowed ଆପଣ ନାଁଟା ଦିଅନ୍ତୁ ଆପଣ ଅଛି
Item 101.
One zero one.
109 of the. There is no criteria, madam. I have got the injury report certified copy along with the statement of the injury, and charge sheet has already been submitted.
Series of criminal cases. Series of criminal cases. How many cases are there, Mr. Puru?
The copy of the charge sheet, madam. The injured has been discharged.
What is the name of the injured as per FIR?
P. Rahul.
P. Rahul Kumar.
The statement is also there. His statement is also there.
Where is that discharge?
See, कहूची the statement रे निजे कहूची.
P. Rahul Kumar.
Last statement one. Just prior to the injury.
Kenta Rahul Kumar.
ଆଜ୍ଞା ସେ ନିଜେ କହିଛି ଯେ ମୁଁ ଭାଇ ଜାଗାରେ ଚିକିତ୍ସିତ ହେଲି ସେଠି ଯାଇକି ଷ୍ଟିଚ୍ ପଡିଲା ତାପରେ ମୁଁ ଭଲ ହେଇକି ଘରକୁ ଆସିକି ଏଇ ଜମାନବନ୍ଦୀ ଦଉଛି। ଏଇଟା ଗ୍ରୁପ ଭିତରେ ଝଗଡା है ଚାର୍ଜସିଟ୍ ଅଲରେଡି ସବମିଟ।
Or the land council for the petition and council for the state. Considering the submission made by the land council for the petition, that the petitioners are young boys and they are in judicial custody since
27-25
27 2025. Charge sheet submitted.
ଚାର୍ଜସିଟ୍ ଆଗରୁ
They have been, and the charge sheet has been submitted against the petitioner under section 109, 117 bracket 2, 3 bracket 5, 296 and 351 bracket 3 of BNS, copy of which is filed and taken on record. And further submission that injured has been discharged from the hospital and is quite hale and healthy. And to that effect, he has filed the statement of the injured as well as the other witnesses and also the certified copy of the injury report, which shows that the injured has sustained one injury on the epigastric area. And after hearing the land council for the state who submitted that the petitioners are for total antecedents, I am inclined to release the petitioner on bail, subject to condition that they shall appear before the IAC of Jayapur station once in a week on every Sunday in between 10 to 6 for a period of 3 months, and they shall not involve in any criminal activities, shall not try to come in contact with either the injured or any of the prosecution witnesses, shall appear before the land and trial court on each date, which the case shall be posted. Violation of any terms and condition shall entail cancellation of bail. Allowed.
Item 102.
Item 102 on behalf of SN Misra committed to withdraw. On behalf of SN Misra permitted to withdraw.
Where you filing, you have no power, sir.
No power.
But how can you write if you have no power? How can you file the withdrawal memo? So, what is your name?
S.K. Rautre.
Huh?
S.K. Rautre.
Mr. S.K. Rautre and counsel appearing for Satyanarayan Mishra, but -4 submits that he has been requested by Mr. Mishra to make a mention of withdrawal of the bail application. In view of such submission made, the bail application is disposed of as withdrawn. Yes.
Item 103.
Offense under section 318, 319, 351, 336 and 340, Your Worship. The entire allegation is of rupees 14,796 rupees, where he has cheated 2 pair of jeans, 2 shirts, and 1 trolley bag. There are 3 antecedents, including this affair. And in one, Seta recovered on 29/2025, they have recovered. On 6/9/2025, this incident has occurred. On 29/2025, FIR was registered in Russia. 6/9/2025 issued incident से cyber police station inform करते, but on 29/2025, where he was arrested,
and involved in Kahala PS case number 323/24 and Kurihat PS case number 109/25.
Kurihat case actually.
My lord.
When you are taken into custody,
29/2025.
Or the Land and Council for the petitioner, Land and Council for the state, considering the submission made by the Land and Council for the petition, that the petitioner is in judicial custody since 29/2025, and the stolen articles have already been recovered. Stolen articles, or it is a article cheated, stolen,
say cheat karki impersonating,
and the articles stated have been taken away by cheating, have already been recovered, and offences are triable by magistrate.
No, your lordship, is sessions, one and
One session. And after hearing the Land and Council for
charge sheet has been filed in the meantime.
Acha, further submitted. Have you got the copy of the charge sheet?
I've got a photocopy of this.
Pass on, pass. And
111.2 is there.
111.2.
In the meantime, on completion of investigation, charge sheet has been submitted under section 318/4, 319/3, 351/2, 336/3, 40/2, 111/2. It is 2B of the BNSF, and after hearing the Land and Council for the state, you submitted that the petitioner has got 2 criminal antecedents. I am inclined to release the petitioner on bail, subject to condition that he shall appear before the IIC of Gargabajar police station once in a week on every Sunday in between 10 to 4 for a period of 3 months. Shall not indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of the bail allowed.
Item 104.
May I please not, my lordship. My lord, the prisoner is in custody since 15/6/25. It is a cyber crime. And originally the FIR was registered under section of 4 sections. And subsequently, the other sections are inserted here as per the order sheet revealed from the order sheet. The case of the allegation of the against the petitioner is that he has informed the informant that 67 lakhs has been deposited in his account, so that he was requested to transfer this.
What about the criminal antecedents?
No.
But no share. No.
What is the
67 lakhs?
No, what happened to that amount?
May I read the statement of Rosni?
That has been recovered or not? Because it has been transferred to an account. So whether he has withdrawn it or it is there or something like that. What is your instruction? Because it appears that he got a call from a particular phone number, and that officer, his caller introduced himself as an officer from the cyber cell, and then accordingly it was linked to his account in Canada Bank, and 67 lakh was stated to have been credited. So he then connected to WhatsApp video call personally introduced as a judge who purportedly issued the online order. Was threatened that if I disclose the matter to anyone, my son's life would be at risk. Question.
As per my charge sheet has been submitted.
Give instruction about submission of charge sheet and what happens to this amount, which was transferred to the account.
Without any inquiry, he has transferred the amount in so many days.
This case is a cybercrime offense. The Land Council for the state submitted
that though he has received the case diary, but he wants to obtain specific instruction regarding the amount involved in the case and whether the same has been recovered, and also further instruction relating to the criminal antecedent and submission of charge sheet. Put up this matter on such and such date. Yes, next.
Item 106.
NTB2B, NDPS Act, and quantity of ganja is 9 kg.
9 kg of ganja. Item number 106. What is the date of custody?
Date of custody 26/9/2025.
26/9/2025, 9 kg ganja. Rest of the commercial quantity bar not applicable allowed.
Item 107.
Petitioner is in custody, my lord, since 23/9/2025 for commission of the offence under section 309 surplus 6 and 331 surplus 4 of the BNS Act. My lord, kind of a glance to the page 15, the rejection order, paragraph 4. What is the basis of implication of this present petitioner, my lord? Clearly stated that on perusal of the FIR, Sidderly statement recorded under section 161 CRPC and other connected paper, the fact remains in that on 17/9/2025 at about 2 p.m., 4 persons entered into the house of the informant by covering their face and started assaulting the informant by means of the lathi and iron rod, and then looked for gold ornament. But when he raised hula, the said culprit left the spot by taking away 2 number of mobile phone. So on the same day, he lost the FIR, which was registered so. During investigation, the IO examined the informant and other witnesses, visited the spot with scientific team and collected physical clue, received the information about the apprehension of Ajay Das and Umesh Das in Sadar case number so. In another case, 2 accused persons were arrested and they confessed that they have committed this crime along with this present petitioner. So the basis of implication of this present petitioner, the co-accused confession, that in which they had confessed that they, along with one Jagadas is the present petitioner before your lordship, had committed the crime, and then he conducted the raid on the house of the accused Jagadas and arrested him and seized the stolen mobile phone from his possession and made the prayer for remand of the co-accused person in this case till date.
So what was recovered from your possession?
So that is as per the rejection order, my lord, that mobile phone. Seized one of the stolen mobile phone from his possession.
Or the land council for the.
And there is an antecedent, my lord. He is involved in Kendrapada PS case number 4/25. Involved in Kendrapada PS case number 4.
Which line? Which line? Which line you are reading, Mr.
Instruction ଆସିଛି ଯେ ଗୋଟାଏ place ନା କେତେଟା?
Madam, in the rejection order, it has been mentioned.
कितने नंबर है पेज को उन्हाती?
Page 15, madam.
हाँ?
Page 15.
Page 15, अच्छा. वो कौन लिखा है ये? Oh, there is one case instituted.
Madam.
Are the land council for the petitioner and council for the state. Land council for the petitioner submitted that the first information report was lodged against unknown persons, but some of the co-accused persons were taken into judicial custody, and on the basis of their statement, the petitioner was arraigned as an accused, and from his possession, one mobile phone was seized. We submit that in view of the and was taken into judicial custody on 23/9/2020, and one mobile phone was seized. He further submits that in view of the available material on record, the bail application of the petitioner may be favorably considered. Land counsel for the state has pointed out that there is one criminal antecedent against the petitioner. Considering the submission nature of the petition against the petitioner, since the implication of the petitioner in the case is based on confessional statement of what used,
I'm inclined to release the petitioner on bail and put a condition that he shall appear with the IOC for 3 months on Sunday. Allowed next. Public.
Item 108.
Your earliest offense is under section 21B of NDPS Act.
65 grams of brown sugar.
65 grams of brown sugar. To that effect, the petitioners are in custody since 21/9/25, and in the meantime, final PR has already been submitted, ma'am. In the meantime, final PR has already been submitted.
Or the land council for the petitioner and council to be clear. Considering the submission made by the land council for the petition, that the petitioners are in judicial custody since 21/9/25. Quantity of brown sugar stated to have been seized from the possession of the petitioners is 65 grams. And in the meantime, on completion of investigation, final PR has been submitted. And absence of any bar under section 37 of the NDPS Act for such quantity. And after hearing the land council for this stage, I'm inclined to release the petitioner on bail allowed. Yes.
Item 109.
20B 20B 2B of NDPS and 8 kg 500 gram.
8 kg
And
500 grams.
petitioner is in custody since 16/7/2025.
16/7/25, 8 kg 500 grams. Results in the concept if are not applicable allowed next.
Item 110.
And that petitioner is in custody since 23/9/2025 and 20B2B 7 kg.
7 kg.
23/9/25, 7 kg lesser than concept and not applicable.
Item 111.
Lordship, 20 sealership, 28 kg involved.
CDSU?
No, she did not.
Item 112.
And item. Custody since 2025 custody since 10/2025 addition minorship railway ଚାକିରି କରିବା as per FIR instruction as per paper page 14 ରେଲୱେରେ ଚାକିରି କରିବା ପାଇଁ 13 ଲକ୍ଷ ଟଙ୍କାର ଠକେଇ ରେଲୱେରେ ଚାକିରି କରିବା ପାଇଁ as per FIR instruction minorship page number
You are involved in similar cases and an amount of rupees 62,50,000 has been
already paid in this matter minorship.
In this case, what is the amount?
Amount of 13 lakhs.
Deposit that amount.
Minorship, I pray, man. I pray. 2 case already pay.
No. Are you ready to deposit this amount?
Minor, I pray.
Present petitioner land council for this case. Considering the submission made by the land council for the petitioner that the petitioner is in the issue of petitions.
10/7/2025 minorship.
10/7/2025. Charge sheet has been submitted and the cheating amount is 13 lakhs. And after hearing the land council for the state, I'm inclined to release the petitioner on bail subject to conditions that the petitioner shall deposit rupees 13 lakhs in the kilo. Yes, next.
Item 113.
20B2B 12 kg ganja and petitioner is in custody since 23/9/2025.
That is just 12 kg, but the rejection order left at page 10. 1 to 3 ଶୂନ
That 12 kg.
12 kg ଲେଖା ହେଇଛି ତ?
ଆଜ୍ଞା page 10 ବି 12 kg ସେ 3ଟା 0 ଦେଇ ଦେଇଛନ୍ତି।
3ଟା 0 ଦେଇଛି।
ନାଇଁ 12.000
ଆଜ୍ଞା
obviously kg ର ଗ୍ରାମ ଟାକୁ କଲା ବେଳକୁ 3ଟା ଶୂନ ରହିବ ତେଣୁ 12 means 12 kg 000 ଗ୍ରାମ ସେମିତି ଲେଖା ହବା କଥା or the learning council ଏଟା ଅଛି କଷ୍ଟଡି ହେଲା 23/9/2025
12 kg, lesser than commercial quantity, bar not applicable, allow next.
Item 114.
114 initial FIR was lodged against the criminal breach of trust matter. Then it on forwarding under section 392 and 406 of IPC, corresponding section of IPC matter. He is in custody since 9/10/2025. Proof of the case is that he is simply asking for a scooty of the son of the informant minor to withdraw money from nearest ATM minor, then faded away with that scooty minor. In the meantime, the scooty was seized from the present case.
Yes.
He has no criminal antecedent.
PD available.
Or the counsel for the petition and counsel for this waiver. Considering the submission made by the land counsel for the petitioner that the petitioner is in judicial custody since 9/10/2025, and the allegation against the petitioner that he took away the scooty of the son
of the informant.
It has already been recovered from the possession of the petitioner, and after hearing the land counsel for the state, and inclined to release the petitioner on bail allowed.
That would be.
Item 115.
May I please, Lords? My lord, initial FIR was lodged under section 296, 115, 2, 315, 351, 2, my lord. 294, 323, 506, 5 exclusive, my lord. And subsequently, the petitioner was forwarded by adding 109, 307, my lord. Allegation of 307 is that, my lord, he threatened with bomb to throw, but no one was injured or not, yes, my lord. And no antecedent, only threatened. No one is injured.
In hurling lekhaiji explosive bomb.
My lord, kindly is running page 13, my lord.
Bomb was thrown or they just threatened?
Threatened, my lord. Running page 13, my lord.
Running page 13?
Yes, my lord. Second paragraph, my lord. While I am placing the relevant part, my lord. While the security guard objected, the petitioner abused him in pelted stone to the factory premises and fled away from the spot.
What about the criminal antecedent?
No antecedent.
Bomb was seized.
Only
last paragraph. The bomb was seized by the IO.
He was on hold, my lord.
You are in custody since when?
My lord, custody since 29/8 to 2025, my lord. No antecedent.
What about the charge sheet?
Charge sheet not something.
Or the land council, the petitioner and counsel for the state, considering the submission made by the land council for the petitioner that the petitioner is in judicial custody since 29/8/2025, and so it is the case of the prosecution that the petitioner was threatening to haul a bomb, but there was he has not done, and the prosecution case that the bomb was seized from the position of the petition, and further submits that in view of the nature of acquisition, the bail application of the petitioner may be favorably considered. As I say, I have to beg for them to TD strategy with the land counsel for the state, on the other hand, oppose the prayer for bail. Considering the submission made by the land counsel for the parties' nature of acquisition against the petitioner, fear of detention in judicial custody, and inclined to the petitioner, bail shall not indulge in any criminal activities. Allowed. Next.
Item 116.
No, that's 20 kg 650 gram. 20 kg 650 gram gunja.
CD and CA available. CV available.
CA9
CD available. 6 some time to obtain the criminal antecedent.
Item 117.
Custody since 26/9/25 for commission of offence 64(2) of BNS and other offences of BNS. There is a dispute between the husband of the victim and the petitioner. The victim is 23 years old.
What is the stage now?
charge sheet is submitted and a case committed to Court of Sessions.
Where is the copy of the charge sheet?
Not now.
You are, what is the age of the victim?
23 years only.
Grand counsel for the petition and counsel for the state. Considering the submission made by Grand counsel for the petition, the petitioner will discharge of since 26/9/2025. In the meantime, in completion of investigation, charge sheet has been submitted under section 332 bracket reading, 324 bracket 3, 361 bracket 3, and 64 bracket 1 of PNS. And after going through the statement of the victim recorded under section 183 PNSS and other material available on record, is inclined to release the petitioner on subject to condition that he shall not come in contact with the victims and or any other prosecution witnesses and appears before the Lion trial in each state to which the case shall be posted for trial. Violation of any terms and conditions shall entail cancellation of trial. Person out.
Item 119.
May I please? So 41B and Milord, we have identities actually. 2 kg of ganja and 300 bottles of cough syrup was seized. Of the total rejection at page 15. And on compliment pistol and 5 live ammunition purpose. From 2 persons.
What about the criminal antecedent?
It's number 1 or 2 antecedents. If you in the order of the petition at page 4, minute 5. This number 2 has no antecedents.
That wouldn't frustrate quantity if they fill
So somebody mentioned chemical quantity
300 bottles money, so
100 ml.
And the entire quantity, if it is taken into consideration, then 300 into 100 becomes the ml. Suppose it is to be divided, perhaps it becomes commercial quantity. Yes.
The potent mention quantity 100 ml.
That it's not necessary that
yes, sir.
It should be separated. The entire quantity is to be taken. So 100 ml gote bottle. So ordinarily it is expected that it should contain. So by the way, you take instruction about the criminal antecedent. CD available, CRO instruction. Yes, next.
Item 120.
One charge sheet submitted 109 and for 20 August. One injury in the left hand wrist, that is grievous. Injured already discharged from the hospital.
Who is the injured?
Injured Santosh Kumar, informant himself.
Discharge will put by there.
Is the injury report in charge sheet and injury report.
The land council for the petition, land council for the state. Considering the submission when the land council for the petition that the petitioner is in
judicial custody
20 August.
since 2025. And the informant in this case is the imbue who has sustained one patient, but he has been discharged from the hospital and critical and happy. And in the meantime, in completion of the investigation, charge sheet has been submitted under section 126 to 305 bracket 3, 296, 351 bracket 3, 351 bracket 3, 109, 331 bracket 4 of UNS copy of the final taken report. And after hearing the land council for the state, on to allow it.
Item 121.
May I please announce? My lord, petitioner was remanded in this case on 12/6/2025. Offense under section 303 sub 2.
Any antecedent is there, madam.
My lord, I am filing active to that.
In the rejection order, that is the same criminal antecedent.
February
12/6/2025.
Of the land council for the petition land council for the state, considering the submission made by the land council for the petition that the petitioner is in judicial custody since
12/6/2025.
12/6/2025. The offense is traveled by magistrate and charge sheet
has been
submitted in the meantime, and the submission of the land council for the state that there are number of criminal antecedents against the petitioner as appears from the rejection order, and after going home to the comprehensive affidavit filed relating to the status of those cases, I am inclined to release the petitioner on the subject condition, which shall appear before the IAC of Vadodara Police Station. Once in a week on every Sunday in between 10 to 4 for a period of 3 months. Yes.
Okay.
And the sub item, sub item, the offense is under section 3032 of the BNS Act and the petitioner.
11 antecedent is that
in respect to
Hon'Ble
comprehensive affidavit as per the instruction of the court. And in all the cases, he is on bail, except this one. Copy. Sir, copy.
Exact and year sheet. I think we are for this, we are not just next. Comprehensive.
122.
Yeah, it is the victim is the informant. The subsequent story as narrated in the FRA that since last 8 years,
no,
this is the PP supplier. 89 was removed. Only offense on the section.
They didn't get the case.
85 was discharged from 85. Only 493.
Yes, ma'am.
123.
123.
Here we got offense 3084 minute. 3084 of PNS. And the informant is the father of the petitioner. In an unfortunate situation, this thing has happened and FIR is unknown. It is in custody since 14/10/2025. The allegation is that the father has said that somebody has kept some letters in my Innova car. And based on that, the police investigated and police has said that his son is involved.
Police has said
that his son is involved. And in the rejection order also, it reflects.
Son means
ତା ବାପାକୁ ଧମକେଇକି 35 lakhs
That is the allegation. And in the father has also filed an affidavit that is reflected in the rejection order law that I do not want to pursue the matter because father didn't know that this will be the situation. And son is not involved. When he went to police station, he came to know that his son has been arrested.
ନିଜ ବାପା କାରରେ ରଖିଥିଲା
ନା ଗାଡିର ପଛପଟେ ସେ କହିଲେ ଯେ ଗୋଟେ ଲେଟରଟେ ଅଛି ତାକୁ ଡିମାଣ୍ଡ କରୁଛୁ ତାପରେ ଯେତେବେଳେ ଫର୍ଦର ଇନଭେଷ୍ଟିଗେସନରେ ପୋଲିସ କହିଲା ଯେ
ଜଣା ପଡିଲା ଯେ ନିଜ ପୁଅ ତା ଦେହରେ
ପୋଲିସ Son is Milord is a physically
କେବେଠୁ ଅଛି
14-10 ରୁ ଅଛି physically challenged person Milord having hearing impaired and
ଗୋଟେ ଫିଲ୍ମ ଆସିଥିଲା ଡି କମ୍ପାନୀ ନା କଣ
in fact Milord what has happened when the father also Milord he has understood the rigors of the years and the father has filed the affidavit. The son has said that police has used the third degree and he has extracted the truth Milord from the mouth of the petitioner. He has not is not involved. He said to the father that
ଆଉ କେତୋଟି କେସ୍ ଅଛି
no anticipation. First offender is a physically challenged person.
Petitioner and counsel for the state considering the submission made by the land counsel for the petition that the petitioner is a young boy is it about 24 years and having criminal antecedent and he is a physically disabled person custody since 14/10/2025 offense is traveled by magistrate and he has tried to commit extortion from his father. So subsequently came to his knowledge and the father of the petitioner, among the informant in the case, has filed an affidavit that he doesn't, in the court below, that he didn't want to proceed with the case. And after reading the land counsel for the state, I'm inclined to release the petitioner on a case live.
Item 124.
6 box
Notice.
Item 125.
Offense by 5A of Explosive Substance Act. Accused in custody since 25/9/2025. In the meantime, charge sheet already been submitted.
On
35 numbers of Godama live bomb.
Godama.
Deepavali time.
Deepavali time.
One unceased amendment, my lord.
Or the land counsel for the petitioner and counsel for the state, considering the submission made by the land counsel for the petitioner that the petitioner is in judicial custody since 25/9/2025, and in the meantime, on completion of investigation, charge sheet has been submitted under section 5A of the Explosive Substances Act, and the allegation against the petitioner is that he had kept firecrackers that had 35 numbers of Burma, which was seized from him. And after hearing the land counsel for the state and going to the charge sheet and the statements of the witnesses filed by the land counsel for the petition with a memo, I'm inclined to release the petitioner. Will allow.
Item 126.
Wait, please, Your Lordship. The present petitioner is in custody since 8/8/2025.
I am the informant.
Initially, Your Lordship, FIR was lodged under section 103, Your Lordship, but subsequently charge sheet has been submitted under section 85, that is 498A of IPC, 80, 304B of IPC, and 108, that is 306 of IPC. I am the husband. The
What is the cause of death?
cause of death is due to antemortem hanging.
Page 17, Miller, the rejection order.
Hmm.
The inquest report of the deceased revealed that the deceased had injury on her face, right hand, ankle, left leg, finger. The PM revealed that there is a ligature mark around the neck in the form
Also,
of.
it is antemortem in nature, and it is
Yes,
so that is the reason why 302,
due to the
which is a
asphyxia.
one.
Yes, Your Lordship, but I'm submitting the certified copy of the charge sheet along with the postmortem report. There is no injury on the body of the victim, Your Lordship. And that is why it was converted to 306, Your Lordship. In the charge sheet also, and in the statement
How
of it,
many years after marriage?
Your Lordship, that is the only predicament is very less brief. It was a love marriage. The victim started doubting the petitioner, and while the petitioner had gone to obtain a office bhoji, she has committed suicide. I have filed the certified copies, Your Lordship. Brief facts of the case also makes it very nice.
You annex that PM report.
Yes, Your Lordship, the last page of the bunch.
This is with Sasmita Das.
Yes, Your Lordship.
Yeah, what do you say, madam? You are appearing for.
In front.
What is your objection? Or you have no objection if the petitioner is enlarged on paid? You are this Sukanti Das is the informant is the
Mother of
mother of the deceased.
Indeed, yes.
Or the learned counsel for the petitioner, learned counsel for the state, and learned counsel for the informant. Dolly Rani Behu Roy, learned counsel has entered appearance for the informant Sukanti Das and files Vinama. This is taken on record. Learned counsel for the petitioner submitted that the petitioner is in judicial custody since 8/8/2025. And he has been charge sheeted under section 85, 80, and 108 of BNS and section 4 of Dowry Prohibition Act. She further submits that the charge sheet indicates that after marriage, the deceased was suspecting the character of the petitioner, who was her husband, and she was trying to keep the petitioner under her control, for which a quarrel ensued was there between the two on most of the days, in most of the days. And on the date of occurrence morning also, there was quarrel between the petitioner and the deceased. and the petitioner left the house to attend a feast. And since the deceased was in an angry mood, she did not cook food and slept in her bedroom. And when her mother-in-law called the deceased, she did not respond. And the immediate neighbor was called, and the door was forcibly opened by means of a crowbar, and it was found that the deceased was hanging from the ceiling fan by means of a sky-colored apron. Thereafter, the deceased was shifted to Soro CSC, where the medical officer declared her death. The postmortem was conducted over the dead body of the deceased, and it was opined that the cause of death of the deceased was asphyxia as a result of antemortem hanging due to constriction of the neck. Land Council submits that even though initially the FIR was registered under Section 103 of the BNS, but since the investigating officer didn't find any material for such offense, charge sheet was not submitted under such offense. He submits that in view of the factual scenario and under which the deceased has committed suicide, and the period of detention of the petitioner in judicial custody, the bail application may be favorably considered. He has filed the certified copy of the FIR, charge sheet statements, and the postmortem report which are taken on the Land Council for the informants, also Land Council for the state, oppose the prayer for bail. Considering the submission made by Land Council for the respective parties, nature of accusation against the petitioner, surrounding circumstances under which the deceased committed suicide, the postmortem report finding, the period of detention of the petitioner in judicial custody, and inclined to release the petitioner on bail allowed.
Item 127.
May I please, Your Lordships? Your Lordships, it's a case under Section 21B of the NDPS Act. Petitioner is in custody since 16/9/2025. At page 12, police has specifically written that, my lords, it is 36 grams of brown sugar has been seized from the conscious possession of co-accused person, my lord. And in this case, charge sheet has already been
What is the quantity?
36 grams, my lords.
It was seized from whom?
Kisan Prushti, Your Lordships, the co-accused person. At page 12.
Both of you are going together in that motorcycle. Or the Land Council for the petitioner and counsel for the state. Considering the submission made by the Land Council for the petitioner that the petitioner is a young boy as in a judicial custody since 16/9/25, and quantity of brown sugar stated to have been seized from the possession of the co-accused is 36 gram 660 milligram, which is lesser than commercial quantity, and therefore bar under Section 37 of the NDPS Act is not applicable. And after hearing the Land Council for the state, I am inclined to release the petitioner from bail allowed.
Pledged, Your Lordship.
Item 128.
May I please, Your Lordship? And offense under 21B NDPS Act, allegation as per the purchase for sale of cough syrup at a marketplace is not proved by prostitution 41, 42, 50 of NDPS Act not be complied. And 69(7) number of cough syrup 2 mg, codeine and triple of hydrochloride. Petitioner sold cough syrup.
Have you?
No criminal antecedent minor.
It is not available.
And also get the criminal antecedents also. No? The Learning Council for the state seeks some time to produce the case diary as well as to obtain criminal antecedent instruction relating to the take instruction relating to the criminal antecedent if any against the petitioner. This is not the urgent problem. Yes, next.
129.
Custody since 8/9/2025. Offenses are under section 126, 64(1), 62, 115(1), 251, 55 of BNS. Allegations of attempt to commit sexual assault on the victimized. Allegation is that while the victim was returned from a equisia function in another co-villager's house, the petitioner along with another co-accused tried to commit sexual assault on the victim. The victim.
What is the now stage?
So flat sheet is not been submitted.
As in city of criminal antecedent.
Item 130.
Notice next.
Item 131.
23 kg TB 23 kg 23 kg 20 kg में 23 kg
commercial quantity. CTCA next.
Item 132.
May I please ask? My lord, 46 grams of brown sugar was seized from the conscious possession of the present petitioner, and he has no criminal antecedent, and final PR has already been submitted, and he was arrested on 24/9/2025.
24/9/25. Quantities of
46
brown sugar is 46 grams, lesser than commercial quantity, bar under section 37, not applicable. And after hearing Learning Council for the state, as a final PR has been submitted, bail application is allowed.
Okay.
Item 133.
Charge sheet has been filed under section 1031 of BNS, that is corresponding to 302 302 of the IPC, and deceased name is MD Umar Shah, and occurrence took place on dated 16/7/2024.
Since when you are in custody?
I'm in custody since 21/7/2024.
What is the name of the deceased?
MD Umar Shah. MD Umar Shah.
Date of
occurrence took place on 16/7/2024.
Eyewitnesses are there.
Eyewitnesses are there.
Who is eyewitness?
Asapurna Burman.
Asapurna Burman.
Asapurna Burman, the owner of this factory.
Asapurna Burman. Burman, acha. What she has stated, or
she has
stated that both the working under that one company, there was altercation on the rate of occurrence when in drunkard stage the deceased was tried to scold and assault the present petitioner, pick up a rod and give a blow on his head.
And once
rod on the head.
Position
antemortem head injury and its complication, that is the PM report.
The deceased also tried to assault the present accused person, and in order to self-defense, the petitioner assaulted on the head to the deceased. There was no intention or motive.
What about the criminal antecedent?
No antecedent. 59 years.
And what is the position of the trial now?
Charge sheet file. Trial has not yet commenced. Only charge frame. Trial has not yet commenced. Yes, Sunanti Sakhi. Yes,
Petitioner and counsel for the state. The Learning Council for the petitioner submitted that the petitioner is in judicial custody since 21/7/2024, and he has been charge sheeted under section 103 bracket 1 of BNS. He further submits that the occurrence in question took place on 16/7/2024, and it appears from the statement of the eyewitness Ornapurna Barman that during the tussle between the petitioner and the deceased, the petitioner all on a sudden picked off an iron rod.
Deceased.
Deceased picked up an iron rod.
Yes.
Deceased tried to attack the present petitioner.
Deceased tried to assault the petitioner, and the petitioner, in retaliation, assaulted the deceased by means of an iron rod on the head, and which ultimately resulted death. The Land Council submits that in the meantime, case has been committed to the Court of Session. Charge has been framed, but the examination with witnesses is yet to start, and therefore the bail application may be favorably considered. Land Council for the state opposed the prayer for bail and faced the statement of eyewitness Ornapurna Barman and also the postmortem report.
Binod Kujugar, 1-2 scene.
There is the postmortem report which indicates that cause of death of the deceased was due antemortem head injury and its complication, and the injury could be caused by hard and blunt object. Considering the submission, measure of accusation against the petitioner, surrounding circumstances under which the crime in question took place, and period of detention of the petitioner in judicial custody, and inclined to release the petitioner on bail subject to condition that he shall appear before the London trial court on each date to which the case shall be posted, not try to tamper with the evidence, shall not indulge in any criminal activities, violation of any terms and conditions shall entail cancellation of bail. Yes, next.
Item 134.
Yeah.
The present petitioner is in custody since 13/8/2025. Commission of offences punishable under section 21B and 29 of the NDPS Act. 500 bottles of cough syrup, Your Lordship, amounting to 50 liters.
9 criminal answers.
Yes, Your Lordship. He has been acquitted in some. That is why we have already prepared the comprehensive affidavit.
State has pointed out that there are 9 criminal antecedents against the petitioner. Land Council for the petitioner has filed a comprehensive affidavit relating to the status of those cases and handed over a copy of the same to the Land Council for the state to seek some time to verify this and put up this matter and such and such date. Yes, next.
Item 135.
Please, Lord. So, petitioner profited from 11025. Alleged offense under section 318(4) or 319(2) of BNS Act and 66 of B of Technology Act. Allegation is received.
Allegation is that the informant got a call from a lady named Jessica Agrawal to luring him to invest in F&O.
Informant.
Cyber crime.
I pray that the city has received. I pray for next week one.
Land Council for the state
My involvement is 2 lakhs.
he has received the case very, and since it is a huge brief now, and he has not gone through the same, the matter may be taken up next week. Please, this matter next week. Yes.
Item 136.
May I please, Your Lordship? Lordship, 20 2 C of NDPS Act, Your Lordship, 50 kg of ganja, Your Lordship.
Commercial quantity, na?
50 kg.
To bring that CD and criminal acts. Yes.
Item 137.
May I please, Your Lordship? The accused in custody since 13/8/2025. In the matter, charge sheet has been submitted on 15/9/2025. Allegation under section 318 to 351 to 353, 75, and 81 BNS. And then the 75 the cottages in the charge city. All are traveled by magistrate manual. Allegation is that the informant received a phone call from the accused petitioner, and thereafter they continued to talk over the phone and develop acquaintancy. The accused petitioner met her at college and on the assurance of marriage took her a coffee farm near the college where he allegedly had sexual intercourse with her under a false pretext of marriage.
What is the position now? Charge sheet submitted.
That's it, something no.
Pass on that statement. Let us see. Hey,
Both are went to Ernakulam.
just a minute.
Up to 161, zero marker there is prisoner, 164 is there.
बयस 20 वर्ष ना or the land council for the petitioner and council for the state, considering the submission made by the land council for the petition that the petitioner is in judicial custody since 13/8/2025. He is a young boy, aged about 25 years. In the meantime, on completion of investigation, charge sheet has been submitted under section 318 bracket 2, 351 bracket 351 bracket 3, 75 and 81 of the BNS. And after going through the statement of the victim, recorded under section 183 of the BNSS, victim is aged about 20 years, which shows about the love affair between the two and keeping physical relationship with each other number of occasions. I'm inclined to, and other materials available on, I'm inclined to release the petitioner on some not prior to come in contact with the allowed. Yes.
Item 138.
May it please, my lords. My lords, I'm in VC, my lords.
161.
That's a commercial quantity.
Yes, ma'am.
CD and criminal antecedent. Yes, next.
Item 139.
May +1. In the meantime, charge sheet submitted under section 420, 468, 471 of the IPC on the allegation that one land has been mutated in my name. Subsequently, it is found that the registered sale deed which was produced, that is fake one. In the meantime, the sub-collector has already cancelled the mutated ROR and I am in custody since 2/8/25. Having
2/8/25.
Charge sheet submitted on 26/9/25.
Have you got a copy of the
Certified copy of the facts.
or the land and council for the petitioner and council for the state? Considering the submission made by the land council for the petition, that the petitioner is in judicial custody since 2/8/2025 and on completion of investigation, charge sheet has been submitted under section 420, 468, 471 of the Indian Penal Code, trial by magistrates. Copy of the charge sheet has been filed and taken before and after hearing the land council for the state and inclined to release the petitioner on bail allowed.
Item 140.
307, my lord. Allegation that during trial, the present person assaulted the husband of the insured means of a knife to the belly, my lord.
कौन है ना इंजुरी कौन हो
Injury, my lord.
Injury, grievous in nature.
5 cm into 2 cm into 2 cm.
My lord.
left side of the abdominal caused by sharp pointed Ponchisinum or
Like, madam, the victim is under bed rest following medical.
victim. Then what about he has been now attending the ordinary pursuit out of danger?
That
Because in the rejection order it is mentioned that the injured is not really out of danger. But what ଲେଖା ହେଇଛି ତେଣୁ ଆଉ ଦ୍ୱିତୀୟରେ criminal antecedent କଣ?
No criminal.
we have to call criminal out of danger or not, we have to take.
That instruction. Learn counsel for the state submit that though here you have received the case diary. Mr.
Yes.
He has received the case diary, but since the rejection order indicates that from the report it appears that the injured is not fully out of danger. He may be given some time and the investigation is still in progress. He may be given some time to obtain instruction regarding the health condition of the injured and also to ascertain about the criminal antecedent, if any, against the petitioner. Place this matter on such and so forth. Yes, next.
Item 141.
May I please also, earlier occasion, your lordship granted 3 times interim bail mail. It's my custody since 15/11/2020. The trial is till date not commenced, madam. Last occasion, your lordship granted bail to the petitioner while 6 witnesses are examined out of 36. Presently, only 1 witness has been examined, madam. I will glance to page 15 of the bail.
You are granted bail by
3 occasions, interim bail.
No. Last occasion you were granted bail on 12/5/2025.
Yes, sir.
So
at that time, 6 witnesses has been examined.
Okay, you take instruction about his conduct, and I am also calling for a report from the learned trial. The learned counsel for the
Four criminal antecedents are there.
So I am mentioning the learned counsel for the petitioner submits that the petitioner was taken into judicial custody on 30/12/2020, and thrice he has been granted interim bail. And the last time interim bail was granted to him in BLA PL number 4446 of 2025 by order dated 12/5/2025. And after availing the same, he has surrendered in the trial court. He further submits that there is no satisfactory progress of the trial, and therefore the petitioner may be granted interim bail. Land counsel for the state seeks some time to obtain instructions relating to the conduct of the petitioner while on interim bail. Let a report be called for from the learned trial court relating to the status of the case. Matter be placed before the registered judicial who shall do the needful so and so. Matter be placed on such and such day. Conducts report be obtained by the land council for the state in the meantime. Yes, next.
Item 142.
May please. The petitioner is in custody since 23rd of September 2025. Company for offense lordship 105 of BNSS along with 287, 288, 289 of BNS and 45 of the explosive substances of lordship. Relating to the explosion of a
Yes, where is you? Criminal antecedent.
Similar nature of criminal antecedent. Similar nature. Unauthorized use of force.
So what is your instruction about that? 3 cases of similar nature are there. Are you filing any comprehensive?
No, ma'am, I don't.
Get that instruction. The learned counsel for the state has received the case diary and submitted that there are 3 criminal antecedents against the petitioner of similar in nature. Learned counsel for the petitioner wants to obtain instruction relating to the status of those cases and file a comprehensive appeal. Is this matter on such and such? Yes.
Item 143.
And in this matter, learned senior counsel Sri Yasodhantra Das will be appears. Senior counsel is not available now.
You want adjournment, madam? So Union of India CBI is there. Acha, Mr. Nayak is there.
Yes, Your
Mr.
Lordship.
Nayak, the learned counsel for the petitioner seeks for an adjournment, but in the meantime, you obtain your instruction in this matter.
Only on the interim bail part, Your Lordships.
Whatever. How?
Taken up this matter on Monday.
No, Monday it is not possible. I'm fixing it next week because it will come before the assigned bench. It is just as it has just come. What is your good name, ma'am?
Sakuntala Ghosh.
Shakuntala
Ghosh.
Ghosh. Who is to argue this matter?
Senior counsel Yasodhantra Das.
Yashwant Das. Acha. Shakuntala Ghosh submits that Mr. Yashwant Das and senior advocate is supposed to argue this matter on behalf of the petitioner and she seeks for an adjournment. Mr. Sarthak Naik, Lenin, special public prosecutor for CBI, is present through virtual mode. Put up this matter next week. As prayed for, instructions shall be obtained by the land council for the CBI in the matter in the meantime. Yes.
Item 144.
Notice you next.
Item 145.
50 kg. How much, sir? CD अच्छी ना नहीं? CD and criminal antecedent. Okay, next.
Item 146.
Petition is in custody. 21B and 29 of NDP circle. Now have a glance to page 16. 320 numbers of S cup syrup bottles having Korean phosphate and precluded helicon. 270 numbers of nitrogen, 10 tablets in 3 boxes, and 2 small cardboard cartons having 100 notes pentogen. And the injection IP containing 50 injections are recovered from the possession of the accused persons near Jira River.
No, this quantity which you are mentioning, that is wrong. That is not. How do you quantify it to be 64 grams when so many bottles have been seized? It is how many bottles it was?
320 numbers of cough syrup.
320 numbers. So the entire liquid has to be taken into account, not this only the codeine. That is the decision of the Honorable Supreme Court, and you are making a case under Section 21B. Once you take the entire quantity, it becomes a commercial quantity. Your investigating officer is not aware of what.
One bottle 100 milligram.
That is I'm telling. You say one bottle is 100 ml, and you just multiply it, so it becomes.
And this 60, man, kindly page 17, man can see. Codeine phosphate is 64 grams.
That is, Mr. You know that decision where it is said that no, if it is mixed with so and so, the entire quantity, not that only that codeine phosphate will be taken into, but the entire quantity has to be taken into. So,
Operating instruction.
that instruction you obtain.
That's it also filed by law.
Maybe that. Seeing or something like that.
Hira Singh.
Hira, right. Hira Singh. You ask your investigating officer and director of public prosecution to go through that decision. That has been specified that it is not that quantity, but the entire liquid is to be taken into account. That is how it comes. If you multiply it, it will come under commercial quantity. So that fundamental mistake you are committing. And moreover, in this case, have you also instruction about the criminal antecedent?
Criminal antecedent. Criminal antecedent there.
How many cases?
There is a first chapter so far item number 11300. There is no antecedent. Sub item. However, one antecedent and again 3 antecedent.
Sabato Jugmasina, one antecedent of not similar nature, 379 IPC.
The London Council for the State submits that though he has obtained the case diary, and it appears that charge sheet has been submitted. Yes, have you got the copy of the charge sheet?
No, madam, I have not.
But he has to obtain instruction whether charge sheet has been submitted or
A
not.
copy of the charge sheet.
However, the London Council for the petitioner has stated that charge sheet has been submitted, and it is mentioned therein that the offense is one under section 21B of the indication, apart from other offenses. And the CD reveals that the quantity of codeine phosphate is 64 grams. However, the Land Council for the state seeks to obtain instruction regarding the entire quantity of the liquid in view of the decision of the Honorable Supreme Court in case of the decision that they Hira Singh versus Poncheta, ଗୋଟେ କାଗଜରେ ଲେଖି ତାଙ୍କୁ ଦେଇଦେବି reported in so and so ହେଲା ପଢିବେ ସେ decision ଟା ପୁରା ପଢିବେ ହେଲା yes next
Item 147.
May I please, your lord? Sir, my lord, petitioners are in custody since 2027.
Next week assume next week na ଗୋଟେ week ପରେ yes item 147.
May I please, your lord? Sir, my lord, the petitioners are in custody since 22/7/2025, and this is a case of, my lord, ATM tampering. On the receipt of complaint from the customers, my lord, the authorized officer has lodged this FIR. Thereafter, basing on the CCTV footage, my lord, the petitioners were arrested. In the FIR, my lord, they mentioned only they were attempting to tamper the ATM machine, my lord.
But he has not received it. Also, the case diary is not there.
Receipt has already been filed, my lord.
It belongs to Haryana. No, you obtained the case diary. CD and criminal antecedent. Yes, next.
Item 148.
May I please, your lordship, the offences are under section 126, subsection 2, 296, 115, 118, 74, 109, and 3, subsection 5 of BNS, your lordship. Lordship, the petitioner is in custody since 30/8/2025. The allegation against the petitioners are that husband of the informant, there was a altercation, verbal altercation, which turned into a physical fight, and due to which he has sustained physical injury, your lordship.
What is the custody date you said?
Lordship, 30/8/2025.
28
ଆଜ୍ଞା
25
yes lordship.
charge sheet submit ହେଲାଣି?
No,
charge sheet ହେଲା ଆଉ ସେ injured ନା କଣ?
ମାଧବ ଜେନା.
ମାଧବ ଜେନା କଣ lacerated Madhav Jena.
Yes, lordship.
Lacerated wound on the scalp or what? Scalp.
Lordship, in the meantime, he has been discharged from the hospital.
Discharged.
Yes, lordship.
What is the weapon with which you assaulted?
Lordship, Bhujali. Lordship, there are other two accused also. They are the along with the petitioners. Those two accused persons have till not yet been apprehended, your lordship. There is no such specific allegation against us, your lordship.
The statement अच्छी से injured रो. No man. Yes. So how do you say that he has been discharged and he is well and active? Because the rejection order indicates that he was undergoing treatment in a some hospital, Bhubaneswar, due to critical head injury. Dying declaration of the injured could not be recorded due to since he was unconscious. So, where is the document to show that?
Lordship, it is my instruction that he has been discharged.
Let's come to the London Council for the state submitted. You have received the case diary?
Madam.
submitted that though he has received the case diary, but he wants to obtain instruction relating to the health condition of the injured, as it is mentioned in the rejection order that the injured is undergoing treatment in some hospital due to his critical head injury, and the dying declaration not be recorded as he was unconscious. Right? This matter. What is of the authority?
Item 149.
49 in there to SRS, I may be allowed to submit. 303 and petitioner remanded on 22/1/25, page 16 minor kind of evidence. There is a theft of some electrical equipment, and the petitioner remanded in this case. And recently, 4 cases I have been remanded, and 3 cases, and 3 cases I have been granted bail. Kind of glass 22/1/25.
There are 13 criminal antecedents.
There, man.
Counsel for the
I'm filing.
petitioner obtained instruction.
I'm filing, man.
Comprehensive affidavit.
Yes, sir.
He has filed a comprehensive affidavit relating to the status of those cases. Copy has been handed over to the land council for the state. Wants to obtain instruction on the same adjourned. Next.
Item 150.
150, Krishna is the driver, and the owner is also been the charge sheeted, but he is paid. Commercial fund. Again, 75
CD and criminal antecedent.
No criminal antecedent. But in some. The statement.
What are these matters? Yes, next. For the
Item 151.
51 minor, I have sought the copy of the POTA on the OPID council manner. They have to take instruction regarding the property.
Value, sir. I'll obtain it.
Mr. Mahanti, land council submits that so far as the property surety is concerned, he has submitted the relevant documents. He has supplied the relevant document to Mr. Patra, land council, appearing for the OPID special counsel. Mr. Patra is present and submits that he wants to obtain instruction, and the case may be taken up on some other day. Case is adjourned. Yes, next.
Item 152.
Extension of time is allowed.
Item 153.
Extension of time is allowed.
154.
Extension of time is allowed.
155.
The cancellation of bail. Who is appearing for the other side?
This is a third reminder to them.
We have received the instruction from the DSP in charge in form of affidavit will file.
The land council for the land council for the state has produced the written instruction received from DSP in charge. So that relates to that status of the
Charge sheet has been
completion of investigation. Charge sheet has been submitted.
Lordship, we looked into the last order. So they filed the wakalatnama and a phone call had been made to them, but they are not appearing.
No one is appearing for him.
They have filed the wakalatnama.
I see it last year Mr. Naik has submitted, he did not turn up. I am appearing on behalf of.
You are appearing?
Yes, sir.
Where are you? How many times this matter was listed? And you are not appearing, it's a cancellation of bail. You have misutilized your liberty, and the case was instituted, and that was investigated upon, and charge sheet was filed, and that shows that you have the your misutilization of liberty allegation which has been made, that is found to be prima facie correct. So why your bail will not be cancelled? And you have not filed any objection to the bail cancellation application?
Also, kindly give me another chance.
Another chance means what is your good name?
Vishwabhushan Agasti.
Vishwabhushan?
Agasti.
Your name is not there. You are appearing for Mr. Shukant Kumar Naik. Give your name and file the affidavit, counter or objection, whatever it may be. So and so appearing on behalf of Mr. S.K. Naik
Land Counsel for the opposite party number 6 for an adjournment to file objection to the CRLMA, serving copy on Ms. Bini Mishra, Land Counsel for the petitioner. Is this matter on such answers that yes?
Should we record it as a last chance because this is
It will come whenever I'm sitting single, it will come and he will file. Yes.
Item 156.
156 is also batch of content application also may kindly refer to order number 9 that is dated 31/10/25.
कौन है ना से रीट अपील लो
रीट अपील लास्ट उठना 8/8/27 in the status is there also.
So what is your instruction? You have filed the writ appeal but not taking any step, and now the content proceeding has come. You have not complied the order on the ground of
because the compliance affidavit filed 2 to 3 memo has been filed so far instruction. I pray that to next week or some other day, Lordship.
No, it will come in my next sitting. It will come.
Only one thing I'll show you, Lordship. Flag P, they have filed an affidavit in the month of May 2000.
You have to file that compliance affidavit.
The compliance affidavit is in file.
Huh?
Compliance affidavit file.
Not received lekha is
And that compliance affidavit at Flag P.
Flag P.
There they have stated 2 months time is required for listing of the appeal. That was
That
filed
is
in-
not the compliance affidavit. You see, if you are not complying the order and you are filing the writ appeal, you must move the that division bench, and if any interim order is passed, matter is all right.
May sitting so that in the meantime any development will come.
The Learning Council for the state, Mr. Mahanti, submits that the matter may be taken up in the next sitting so that he will apprise this court about the status of the writ appeals which you have filed against the order passed in the writ petition, out of which this contempt proceedings arises. Is this matter on such answer date? Next sitting कर दिया, such answer date करो है ना? Next sitting कर ले पड़े से. Yes, आपने
Item 157.
157. Anybody is there? Puna Mishra पढ़ो. These matters, yesterday I had interacted with some of the persons. Maybe he is either the accused or the complainant. And in some cases, they have stated that the matter has become infructuous. So that is how it has been listed. Okay, call one by one. Next.
Item 158.
158, I am appearing for the opposite party member.
You are there yesterday. You appeared in that.
Appearing on behalf of the petitioner.
Yes. So what happened? You said that the matter has been amicably settled or what?
ମାନେ ଆମିକେବଲ ସେଟଲମେଣ୍ଟ ଅଲରେଡି ହେଇଥିଲା 4,50,000 ଆମେ ଗୋଟେ ଜମି ପରଚେଜ କରିଥିଲୁ ସେ ଜମିର ଆମକୁ ଯେତେ ମ୍ୟୁଟେସନ
This 138 NI Act.
NI Act.
You are the who has challenged it? That Pavitra Mahapatra is an accused. You are appearing for whom?
Opposite party.
Opposite party.
Complaint.
Susri Sangita.
Susri Sangita.
So what is your instruction?
Lordship, matter has been listed after 2 years. I will take instruction in this matter, Lordship.
All right. The Learning Council for both the parties present, when a question was raised about the compromise, possibility of amicable settlement of the dispute.
Settlement 4,000, 50,000, 4,50,000 settlement ହେଲା ହେଲା ପରେ ତାପରେ ସେ କଣ କଲା ଆମକୁ ଚେକ୍ ଦେଲେ चेक देला ପରେ ଆମକୁ ଆମେ ଚେକ୍ ଦେଲା ପରେ ଆମେ ଯେତେବେଳେ ଚେକ୍ ଦେଖିଲା ଚେକ୍ ବାଉନ୍ସ ହେଲା ପରେ ଆମେ 1cc କେସ୍ କଲୁ ତାପରେ ସେ କଗ୍ନିଜେନ୍ସ ଅର୍ଡର
The learning counsel for the petitioner seeks for an adjournment.
2022
Then why this interim order will remain?
interim order 24/11/2022
May I say one thing, Lordship?
You face the trial and get acquitted.
Lordship, only one thing, Lordship. I have challenged the order of cognizance, Lordship. Let the matter be had. I don't have an. I just want to place some rulings before this honorable court that the case has been instituted against a company, but the company has not been added as an accused in this the case before the learned court below. So, in view of the section 141 of the NI Act, I have filed this application before this honorable court.
Who has issued the check?
The company, Lordship. Shogun Infra Private Limited, my lord.
petitioner my lord.
No, my lord. It is no. It has never been issued in my custody capacity, Lord.
Petitioner my lord. Ashish Chandra Mahapatra my lord, check already deposited 21,000 my lord, already received registration fees and mutation fees.
Check amount is Susri Sangita Behra.
Yes, sir.
What is the question of adding the company as a party?
Lordship, the company, the check has been issued by Shogun Infra Projects Private Limited, my lord.
No, should buy this from managing director lekha is.
Yes, my lord. Lordship, kindly have a glance to check, Lordship. It has been issued by the company, but the company has not been added as an accused in this case, my lord.
And check already 21,000 already received.
No, I am talking about the check in respect of which the case has been issued.
Matter be listed on such and such date. Next week or then.
Yes, ma'am.
On next week before the assigned bench, learned counsel for both the parties shall also obtain instruction regarding the settlement. Amicable settlement. Yes, next case.
Lordship, interim order to continue, Lordship.
No,
Yes,
Lordship, I will be highly prejudiced, Lordship, because they have been, notices have been issued twice, Lordship. Kindly have a glance at the previous order.
My lord,
2 times.
Do the learning counsel for the petitioner prays for continuance of the interim order. The learning counsel for the opposite party objected. However, since he has not filed any application for vacation of the interim order, the if any appropriate application is made to that behalf, the same shall be considered next week. Yes, next.
Item 159.
Say withdrawal of
It's a withdrawal memo has been filed. Matter has been amicably settled.
IA number 1138 of 2025. This is an application for withdrawal of the CRLMC. In view of such memo filed, it is filed by the petitioner. The CRLMC is disposed of as withdrawn. Interim order stands vacated. And the second one is a disposed of case.
Disposed of. Amicably settled.
Since CRLMC like the IA number so and so, the learning counsel for the petitioner submitted that since the matter has been amicably settled, he does not want to press this interim application. Accordingly, IA is disposed of. With yes. Yes, next.
Item 161.
Item 58, my name not reflected.
Item number 116. That I will 61. 61. Yes. Item number 161. Bashant Kumar Naik. এটা ବି ଖାଲି କହିଥିଲେ amicably settle ହବ ବୋଲି next
162.
My lord, item 162 may be submitted for withdrawal.
Withdraw କରିଦିଅନ୍ତୁ disposed of as withdrawn. Memo is taken on record. ହେଲା interim order ଯଦି ଥିବ stands vacated କରିବ. Next
163.
ଏଇଟା ବି କହିଥିଲେ ଇଏ ହବ ବୋଲି
160, I am appearing for the petitioner in this case.
Said that he wants to withdraw the matter.
But I don't have any instruction regarding the same.
He appeared yesterday.
The petitioner, man.
He appeared for petitioner appeared.
My lord, we are the opposite party. Opposite party petitioner appeared. I don't have any. I have not received any instruction. To be honest. My lord, opposite party has appeared.
Yesterday. Oh, somebody said that matter has been amicably settled or something like that. Will you take instruction from?
My lord, I'll take instruction.
What is your instruction?
Instructions.
Tali appear kortile pura.
My counsel, senior counsel have appeared.
Seithipai matter aji asila. All right, land counsel for the petitioner.
Sir, the instruction was yesterday we have appeared, but they have not appeared.
Acha. Seek some time to put an instruction regarding the amicable settlement between the parties. है ना? Urgent project. Next.
That's the interim order. Interim order.
Acha. Interim order is shall continue next one date देंगे, है ना? Till say date then, है ना? ये माने continue till from a date देंगे, हाँ? Yes.
Deeply obliged.
Item 164.
Not 164, same parties, my lord.
अच्छा, same parties, ठीक है.
Same parties.
165.
Deeply.
165, my lord, on behalf of Diptiranjan Mahapatra, kindly taken over 1 week after.
No, this was also there yesterday. He appeared for the. Acha.
I am for the petition.
Land counsel for the petitioner seeks for an adjournment and for the particular date जाए दे देवे, है ना? Matter is
interim order to be done.
Amicable settlement instruction देवे, हाँ? Next.
Item 167.
It was amicably settled. I am filing that affidavit on behalf of opposite party number 2.
Which one?
I am appearing for the petitioner, but the opposite party yesterday that was present and.
No, this is filed by that opposite party number 2.
2. Affidavit is filed by opposite party number 2. I am.
Who is the counsel for the opposite party number?
Mr. Ghodai, Vikram Chandra Ghodai.
Where is he?
He is not present today. Perhaps yesterday he was there.
CRLMC number 2256 of 2024. This application under section 482 CRPC has been filed by the petitioner Tapas Panigrahi for quashing the criminal proceeding in 1cc number 30 of 2023. Which is subjudiced in the court of JMFC C. Baleswar and had order dated 26/2/2024, cognizance of offences under section 406, 420 by 34 of the Indian Penal Code has been taken and process has been issued against the petitioner. An affidavit has been filed by the complainant, opposite party number 2, Prashant Kumar Panigrahi, wherein it is mentioned that the matter has been amicably settled between the parties and therefore the opposite party number 2 is not interested to proceed with the case. And it is further stated that if the complaint case initiated by him in 1cc case number 30 of 2023 is dropped, we shall have no objection. And cognizance order dated 26/2/2024 is quashed, we shall have no objection. It is further stated that the affidavit has been filed voluntarily without any pressure or coercion. The affidavit is taken on record. Since the offences are compoundable and the parties have amicably settled the dispute, I'm of the view that no fruitful purpose would be served in allowing the proceeding to continue. Accordingly, the impugned order, the order of dated so in taking cognizance of the offences and the entire criminal proceeding in 1cc case number so pending in the court of so stands quashed. CRLMC is disposed of. What is your good name?
Vikas Kumar Pund. My name may kindly reflected.
Vikas Kumar
Pund. VK Pund.
You are appearing on whose behalf?
Or petitioner.
This Sarathi
Jyoti Mahajan. Now he is in government counsel. Therefore, my name may kindly.
So appears for the petitioner. Yes.
158. My name is not reflected on cost title.
158.
Opposite party मांगा.
हाँ. प्रियरंजन सिंह लिखा है इसे.
डिलीट में ऑब्जेक्ट नो ऑब्जेक्शन दे दीजिए.
अच्छा कहीं अपन वकालत नामा कहीं.
सर ऑलरेडी फाइल है जी आपन पास আছে.
देखिए वकालत नामा.
अच्छा.
वकालत नामा तो अच्छी प्रियरंजन सिंह, मोहनलाल मिश्र, और विश्व भूषण दास. এই তিন জনଙ୍କ ନାଁରେ वकालत नामा ଅଛି. ଆଉ वकालत नामा କାଇଁ ଅଛି ଫାଇଲ କରିଛନ୍ତି.
ଓଡିଶାରେ ଫାଇଲ କରିଥିଲୁ ଆସିକି ଲାଗି ପାରନି ଯେହେତୁ ଲୋକ ଅଦାଲତ ରହିଲା.
କେବେ ଫାଇଲ କଲେ? 22/8/2025. ଏ वकालत नामा ନାହିଁ ନା.
ଲାଷ୍ଟ ଡିଲିଂ ଆକ୍ଟ ଆଣି ଦେଇ ଯାଇଛି ବୋଲି କହିଲେ ମୁଁ ଆଜି ଯାଇଥିଲି ଫାଷ୍ଟ.
Acha, it seems it is stated at the bar that Mr. Sudhanshu Das and his associates have filed wakalatnama for the opposite party, Susri Sangeeta Behra, on 22/8/2025 after obtaining no objection from the earlier engaged counsel. Let the wakalatnama be placed on record and the names of the newly engaged counsel be reflected in the cause list in place of the Mr. Priyaranjan Singh, B. Das and M. Mishra. Hello? It is okay. अच्छा नॉन appears करके नहीं this matter before appropriate bench कोटा 157 out of 161 so 160 तो appropriate bench